honorary judicial officers, advocate, and staff of the district judiciary. All of the attendees here have been actually nominated as potential master trainers for the upcoming equals project, because most of us would be maybe going back to court, and so far we had 4 master trainers, namely Mr. Kama Bhutia, Sri Prajwal Khatiwala, Sri Surat Chetri, and myself so far since the year 2014. So not particularly in the state of Sikkim, but if you look into other states, most of the master trainers were either additional district judges or they have now been promoted to district judges. So we need a new batch of master trainers to carry forward this equal project or the digitization even without the project in the future. So all of you have been nominated by either your district judges or in case of judicial officers by the High Court, that we have sent the names to a committee. They are the potential master trainers. Maybe the list is long, they might ask us to again choose from among them. So that's the reason why all of you are here. So first thing, okay, program schedule. वो नहीं लगेगा. First one is overview of equals project. Now, when we were being trained as master trainers, the time was different. We were more concentrating on how to use these laptops and the word processors, the PDF, how to use PDF files, how to make PDF files. But for us, as of now, I think we have to come ahead of that, because those are very, very basics. We cannot still stick to how to use words. We should by now, since I do not know, most of you who are working in the court have seen the computerization for past many years and have been using it. So on today's date, yes, we can learn, using the word processors, or what we call the MS Word or LibreOffice Writer in a more technical way. That is a different. We will not be training henceforth on those things, because those are very, very basics. We would still be, like a learner if we stick to that. So we need to go a little bit higher level, not technically, but on how this equals project is going on and what may happen in the future in the courts. So considering that, we will not be learning all those. The syllabus which was shown to me was of 2017, and I bifurcated that and only kept those things which should be on our mind. None of us maybe are computer graduates, so we also cannot be that technical in using this word processors, etc. Those who have really studied computers, at the district level itself, those trainings can be done, about an hour or 2 trainings, to those who are actually using the Microsoft Word or LibreOffice Writer. Now, first thing Surat sir asked me was which version of Ubuntu you are using. Now, there is no any official communication that we should do away with Ubuntu, but there has been no insistence since long time. One of the reasons is we do not have anymore the customized version of Ubuntu, which we used to have, I think, till 14 or 12 point something, if I'm not wrong, or 14.04 maybe. We had the customized version, we had that logo of Indian Judiciary and some of the features in the LibreOffice Writer that was added. But now that is not being done. We do not have any more the customized version. So there has been no insistence on use of LibreOffice Writer or, for that matter, Ubuntu. Another reason that we were told, I think in 2017, the last training we had as a master trainer was that the open community, which develops this Linux framework or the Ubuntu, they stopped providing the support for the Ubuntu version. So, and some of the features that is used in the Ubuntu. So that was another reason that we were also asked to GNOME. I do not know the exact pronunciation, but many call it GNOME, GNOME. So instead of Ubuntu, we were suggested to use the GNOME interface, because the support would be provided there. There's no official communication, as I say again, that we should stop using Ubuntu, but I, on my own personal front, we can always use that we can carry that software in a pen drive also, or wherever need arises, we can use this Ubuntu and the LibreOffice Writer, or similar to MS Word, the LibreOffice Writer. We can do that, but I officially would not say that do not use it or use it. But I am not using it. I am now with MS Word only, because as far as judges are concerned, we type judgments. Basic use of laptop when we do it is using typing out judgments, so that we can do in MS Word also. And at one point of time when the project initially began, one of the issue was money, which is not now today. It's above 7,000 crores for the country, the ECOS project phase 3. That's huge money. But when it initially started, there was a fund crunch. It was the union government was still not convinced about the project that was coming up. Now they are fairly convinced after so many years. It began in 2005. So at present there is no fund crunch. So there was quite a reason for using Ubuntu then. One was fund. The OS was freely available. If we would have used MS Word, I think Yulan could say what would be the price of this OS original.
So it comes with Windows, it comes around 5,000.
5,000. So then it could have been 2,500, 3,000 or 1,500, something like that. But that's the cost of one. So many judicial officers in the country, and everyone were being provided laptop. High courts also didn't have much fund then. So that was one reason why Ubuntu was chosen. OS being free, they were saving some 1,000 crores maybe in that. So initially, even I used to think, it was a kind of brainwashing. If Suraj sir would also remember, we would be asked to forget Windows completely. And it was such sessions that after 4 or 5 sessions, even we came back and started telling judicial officers, we had to brainwash it. The main aim was to make, the main aim was we were introducing the Linux system. And most of us were familiar with Windows. So that unlearning had to take place, and we were not told that we were being brainwashed and we should go and brainwash, but it was a kind of that thing which I felt. But nevertheless, that brainwashing was not a bad one. Okay, it was something to bring the officers in tune with the digitization process of the court. But having said that, today most of us are, even if you find from the High Court, we have given no any direction, except the servers are using, I think, Linux platform, and other, we are still not, because Ubuntu, though it's very good, but still it troubles you quite a lot of time. It crashes more than I feel sometimes Windows. The only drawback of Windows is once it crashes and it goes, we have to get the new OS. But with Linux and Ubuntu, we can use that, or we can again install the another one. But it's not that, it's not that in my personal experiences, Ubuntu also has crashed quite a lot of time, and sometimes it functions very weirdly. God knows what's happening to it. We are not computer literate, so we have to give it to some computer technician in the administration. They do something and bring it, it's okay. But after some time again, the laptop which I used last 5 years, it was the OS that troubled me more than the hardware. Hardware is still fine. Some of the keys are not working. It's been 5 years, quite a long time. About 3 years that laptop wrote judgment continuously. So it was used. But OS gave a lot of problem. I had to change the versions again and again despite updating. So yes, there is no bar in using either Linux or Ubuntu. Also, one can use it. We will use it as and when required. I personally will use as and when required. If the Windows, the switch, this is the official laptop which they have given, okay. And if the OS breaks down, I obviously could install Ubuntu only. I cannot ask again for a software, Windows software, if it's crashing again and again, and something. And there is another concept also. I do not know if computer people can tell me how true technically that is, that the Linux or the Ubuntu are not infected much by viruses or something like that. Whether technically that is correct or not, I am not sure. But the reason which we were told when trained was that the software is free, so no one wants to damage it, and because the main purpose of destroying the OS is buy another one. And it is often said that also truth, I cannot vouch for it, that it is the manufacturers of OS who also develops the viruses. Sounds true in today's modern world when business means you just need to circumvent the law. You can bend it but not break it. That's the capital system of business. So it could be true, don't know, we are not in that field. I just made a general statement. So overview of ECOS project. Now we are into phase 3 of ECOS project. Now why this training needs this ECOS project is because this is the only project that is computerizing the code. In future what's going to happen we do not know, but as a master trainer I think the knowledge and concept of ECOS project, where it is at the moment, where it has failed and where it is going to be, is essential so that everyone is at par with this project. Now project as one of the basic element of project is it's going to come to an end one day. Project is not something that will last forever. Then what? So the ECOS project is just for establishing the digitization or the digital processes in the core. Once that is done, project is going to be over, and a center may support very minimally regarding funds also. It's all the state responsibility, and that after. As you all also know, was there that we do not give anything, we do not substitute the hardwares or the equipments. That is all for the state to do, state government, because recurring expenses under the agreement has been given to state governments. So this project is going to come to an end one day. So before that, we in the state ourselves need to be, strengthen ourselves, especially on the financial end, which we are doing as of now, so that one fine day things doesn't get halt. So the role of the chairpersons, if I am correct to call, of the committee at the district level, which are district judges, the role will be to identify your future requirements of funds. Now we are planning to have a meeting quite soon. If not soon, then after summer vacation, that because the government's till June 2nd, no one is going to come. So after that also maybe it will take about a month to come out of that. What do you say? Come out of that festival. That's more, it becomes more festival then. So everyone, we all know, they will say they are doing this or that, no one comes. But by August we are thinking to have a high-level meeting where we demand funds to the state. So at the moment we are roughly ourselves calculating how much a district may need, because we are calculating from the quarterly report that has been given to us by the district about which hardwares are absolutely damaged and are beyond repair and which can be repaired. So we have to project according to this. If one district is reporting 5 desktops to have been damaged beyond repair, with that average we are counting how much a new computer would cost, and we will be putting forth these projections to the state government. So for my average prima facie calculation shows about 3 crores we need from government at this moment to carry on the project for financial year 24-25 and to replace all the damaged items. But we do not know, Suraj sir is here, we will be hanging on him to give us that amount. But nevertheless, if we demand 3 crores, if 1.5 crores also comes, that will be quite a great to begin with. But I am thinking in the future, it should be the district themselves who should be projecting it, because High Court as a centralized body will not be justifying your demands, because we are actually not there in the ground. How much you need it, and there might be cuttings also once it goes to another state. So to avoid that, district have their own budgets in the future while budget is being prepared. I think the district themselves should look into your requirement of fund for running your computer systems or server, whatever it is. And we have already shifted 2 things, if you remember. One is E-Seva Kendra's salary, another is laptops. So there may be slow shift if it does not come from the district itself. So we have shifted this to many will be shifting down there. One fine day will say, no, you repair it from your own. Actually, you also do that only now, because we will not provide funds for repairing and etc. The reason is, I'll show you how center has court of the states is this agreement. This is already signed by the High Court, the Union of India and the state government. All recurring expenses is of state. I will take you to that page. You can see it. These are the parties who are the signatories. First party is the Union of India. It says it will provide funds on time directly to the High Courts for implementation of e-courts. This MMP is, I think it's a copy paste, still not, we are over with mission mode project, but let it be. It works that way at the executive level. The second party will support the third party for sustainability of the e-courts MMP. Second party is the state government. The third party is the High Court. Now this time we had two types of funding. One was that the state was given the option to choose either Model 1 or Model 2. Model 1 suppose that if the state chooses Model 1, then the amount of fund that the central will give or the Union of India will give will not change. But over and above that, if some extra costing is there, because on the e-courts project, suppose if I am buying a laptop, right, the specification and the amount, base amount is provided by the e-courts. I cannot go above that. So if let's suppose the laptop price that the e-courts project allows us to use from their fund is 65,000. But I find a laptop which is 85,000, much better and viable, something to be brought by the judicial officers or court or whatever. Now from where will I bring that remaining 15,000? So those are the amounts that the state government has to give us. So that is Model 1. Model 2 is nothing, but I will not give anything. Simple as that. States choosing a Model 2 would mean, thankfully our state and the guidance of Law Secretary have chosen Model 1. So now they are bound to give the funds which we project, of course after a reasonable demand. So let's see what are the roles of second parties, which is more important. Now, where do we actually need fund is the paperless court, because the amount that is being given, we are thinking of bringing Wacom, and it's for all the courts, including the trial courts. The base amount that has been provided is 2.50 lakhs, but when we are looking into the price, it's somewhere around 3 lakhs or 3.5. The high-end one somewhere around 5 lakhs. So which one to choose, it depends on how much the fund the state would give. But still on today's date, we will not be able to bring Wacom monitors with just the fund given by e-courts. We can bring, but a very low specification. Of course in 2.5 also we can get, but that's a very low specification. So we are now in the next step moving into the paperless court project. So for this we have demanded the fund already to the central government, Union of India. So that fund will soon be coming. So once I think it comes, it should come by July or August, I'm hoping so. And we'll be implementing the paperless court project. And one of the things I want to know from London district judges or even magistrates down there. And before that, I want to congratulate all of you that in one of the programs in New Delhi, Sikkim was the best performing state in step. Still we are underperforming, but comparatively, I thought it's Sikkim, some of the small states like Nagaland and some of Madhya Pradesh, etc., were the best state in end step. That means delivery of summons through that. I don't know, is it really being done? I think the data is being shown out there. From the CIS showing data, that's true data, which the center took it out and, Supreme Court took it out and we were at number 1. So it's being done, Mr. Yule.
Yes, sir, it's been done.
So I do not know, it's been quite a long that I've left East District as a judge. I do not know what's going on there. But when I was there, it was not much. Only few of them were using. So is it a regular process now?
It's on a daily basis, sir.
No, I mean to say they are using it. There's no physical delivery or something like that.
So it depends.
Pure physical delivery.
No, not pure. 100% it's not pure.
Yeah.
But some.
No, that depends upon some reasons which is beyond your control. So which are within your control
It's being done.
is being done. That's quite. Anyone from south?
Yes, sir, it's being done.
Okay.
So we are doing it parallel both. I mean, through end step also, by paper also.
No, that end step requires that. Even if you're going with end step, the paper needs to be given. I think it says so. Okay. North, Srinkala. Okay, where Diche? Okay. It's been done. But does not have much of the mobile networks.
Connectivity is very bad.
So that could be the reason, which is beyond our control. But still, overall, the Sikkim was best performing state in state. Now, coming to paperless, we have a notification from the High Court that such kind of matters need to be compulsorily e-filed. Is that being done? I doubt this one. No, I don't think so. Is it true?
It's been done.
I remember enact is one of them. Matrimonial cases.
No, sir. Matrimonial cases, you cannot e-file them because
No, divorce, it mentions divorce.
FC code is not.
If I don't remember.
We have pressed on the High Court, so the database is not there, sir. FC,
No, divorce you cannot
you
do.
cannot file.
But
But the other cases are being filed.
No, even DD cases.
do you even e-filing, right? So that e-filing mode does not have, right? E-filing application does not provide for that.
For family court, it doesn't provide. For others, it
No, DV also.
DB provides.
TV provides.
It's a criminal case under.
They are saying it provides. Let's clear this out, no?
Sir,
Otherwise we all will
once-
go confused.
But we have to give the hard copy. Why is it?
No, I'll come to that. But is there, can you file DV through e-filing? They are saying yes.
Yes, sir. There is notification and maintenance was there. I have filed it and
No, as a family court it might not be there. No, why will the e-filing give family court? It talks about the types of cases, no?
No, it's registered as a
So the
family.
database is not available because family court is a hidden court.
Maybe the names are.
No, but I forgot her name. Chenga did it, she's saying, maintenance case. So the application is same for all, no? No, then you need to see it. How could Chenga could do it and you also. She did it, she's saying. He filed a maintenance case. Because maintenance actually in other states comes under 125 CRPC and not in the family court. So that could be the reason they have kept that open.
I think we need to ask which court she filed it.
but not
Which court?
No, she will be filing in family court only.
family court. District and sessions court. It is mentioned not particularly family court. It is just mentioned district and family court. Thereafter, it got transferred in the family court.
Database is not there.
First check.
How did it happen?
It might be they are filed in some other court. Not in family. Not in
Some
family.
different court.
No, she is saying that tab says district and sessions court, family court. एक ही जगह में सब.
No, what my computer people are saying is, they first file it in the district and sessions court thing only, then after that it gets transferred. So e-filing
Oh,
for the
okay.
KDC, you're filing it in the district court.
Okay, that has to be transferred by the court itself, no then? But is that correct then? But because it will be shown in the district and sessions court case list, no?
Parties.
Some order has to be passed otherwise, transfer order.
Before registration only, let's say. So when the case details get generated, it comes in family court, criminal case only.
Okay, so someone is e-filing maintenance case, it is coming to the CIS. From there they are transferring this.
I believe, sir, they are filing under district.
Yeah. That is being done.
So there is a notification where it says that the family. That
Yeah,
party
that's
can
the
be
way out.
filed.
No, but why you all can't do that? Is there a problem?
Family court has their own establishment, so we
So
are.
I'll tell you the reasons. Actually, we have received a letter from.
No, but that's the way out. No, what they did.
But the parties will be all visible, so then the parties are supposed to be, not, the parties, the details of the case are not supposed to be.
No, once they transfer it, how will it be visible? They are transferring it to family court only where it's hidden.
But the footprint will be there, sir. It will be-
Footprint, though, we'll check it. I don't think footprint requires to be hidden. To my understanding, but still we can discuss on this. Footprints though need not be hidden. No one will go that. If someone goes that far to find out the details of the party, that person is a thief then. Right. Footprints only some technical people can take it out. So please kindly see on this because that order needs to be complied. No, or we need to change it. No, don't, because we have not said anything that don't file maintenance case, have we? No.
So, but we have been treated with Honorable High Court stating this is the issue. The family court database is not available in GDD as per order of Honorable High Court, right?
So as for the.
No, to NZDC we can still hide. No, after doing what the process, what they did also, we did not release to NZDC because they are before registration they are transferring. So I don't think it will be reflected in NZDC.
E-filing database is pulled from NGT. So e-filing, while doing e-filing, all the data is going to NGT. So if family court is not there, that data is not available in e-files. So you cannot e-file.
No, I got that. But you know, a new case is being filed. Which data is being pulled from NZDC?
Like
While if I
case size,
yeah, then no problem. That can be pulled. No, it does not still disclose which the parties are. The issue which you all are saying is disclosure of parties and identity, whatever. They are saying it cannot, it will not be disclosed because it comes there before registration. We are sending it. So if they can access that maintenance, whatever is being pulled from NZDC, if their computers can access, why you cannot access? Still preserving the preserving the identity of the parties. Identity disclosure once it goes to family court, still access in their system also. That's what I am telling. Can you see into this? We can discuss this one.
around 2016, in the year, we got a letter from High Court. I think it was the direction of the committee itself, not to upload court cases.
I've read that. Let's move on with time. Not to upload means that time, the CIS which was given to us was so rudimentary that we could do nothing to hide the parties. The only thing we could do to prevent that was not to upload it. Now there are buttons in the CIS where you can upload it, still maintain its secrecy.
Like if High Court gives us the direction, that
No,
we
no.
always include family court in there.
That's an old system of, if you want direction from High Court, we have to write it. Otherwise, things which are within your domain, which you can do it, then you can do it. That notification is not of 16, that's post that letter which you are talking about. The mandatory e-filing of cases which the High Court has sent. That is post the letter which you are talking. So you have to assume that all things have been taken care of, even if it was not taken care of. That supersedes, no? Now, even in my times, I was uploading juvenile. Some kind of data must be there. Now, you are just to hide the identity, and people should not know by reading a judgment or orders whose case is about. If we can maintain that, then the number of cases, JJB cases filed, the world should know it. The government should know it. Stakeholders should know it. So completely not uploading is not an answer to that. I think CIS has enough features to do the needful, still maintain the secrecy. That 16, it's about to be 10 years. I don't know which year. One I have read of a letter of Justice Lokur which was there. We were talking about that. That has outrun its time. That letter was written when CIS was very rudimentary. It had no features. You agree with this, don't you? That was of 16 when the CIS was not giving all these things. Now I've still seen the option. You are uploading the order, but you cannot read it. PDF view nahi hunda na. So that is enough filing of the identity of the parties. Right, but what I used to do was I never mentioned because if you see, I'll give you one of the, if you don't agree, I'll give you one of the best reasons, is the High Court or Supreme Court not uploading POXO judgments. We have read it. There are so many POXO judgments, even now High Court is uploading. If we were to follow what you are saying is true, then we could not have uploaded. What the judgment does it is written in such a way it does not disclose the identity details. Right, so uploading is a must to my understanding, no matter what type of case it is, unless there is an express bar from the court or something that you should not upload it. Uploading is a process of judicial processes down there in the court. So if you are not uploading any orders, please see to it you upload it, and those which are to be hidden, you see that you use the scientific method given in the CIS to hide it, so that it is not accessible to all. POCSO judgments are being uploaded, right? Can it be read? Why? I put judgment as being, I do not know this.
Yes, you can read.
No, you said no.
I'm sorry. Slip of tongue.
Dipanjan?
You can read.
Okay. Then what's the difference?
Only the name of the victims are written as section.
That's what. No. Why not in then the CIS? When you can hide it. Please look into this. We can still discuss over the phone or somewhere, because it's not that I know everything.
So like, it would be better if
I'm more concentrated on CPC than the registry thing, but still we can discuss.
it must be better if you upload it, because it will be available in e-filing and step everywhere after it goes there. So actually we are waiting for the direction from the High Court.
No, what goes in NZTG? See, if you have hidden something, will it still be shown in NZTG?
So,
The identities.
so the database,
The whole database,
is
the
not
whole
there.
establishment is not going to NGT.
The database is not there. So for in NGDG, we need a database in NGDG. When we replicate data from our court to
Yes. It has to go and stay somewhere there.
so the place that is where it is supposed, that is not there. It's taken on by the court. So even if we enter it, it will not be shown there. So we have to get that.
No, then see, one thing is, what is the purpose of NZTG? Why we are so concerned with that it should be shown in the NZTG? It may be that they are not showing, but are we to assume that we are not to upload it? One fine day, it stays somewhere in the server. One fine day, they will provide a database there and it will all be put. And suddenly one fine day, they will say to us, so you have not uploaded it. And a second task for us will begin searching for those old judgments and uploading it. So I don't know, let's talk over this outside this training, but I think we need to upload it. I'm quite clear on that thing, everything has to be uploaded. When the Supreme Court itself is uploading POCSO judgments, what sense it makes to us to not to upload orders or whatever it is. हाम्रोबाट त दिनु सक्छ नि त.
So हाम्रोबाट जाँदा
We can give, sir.
That's
We are
what.
doing, sir.
If they are not showing it, then no issue. No
From
problem.
our end it is going.
There is no
Doing
issue.
also, sir, but
No issue.
they have.
Let it be CIS मा त म देख्छु नि.
CIS is there, sir.
तपाईँ लोकलमा
वेबसाइटबाट पनि देख्छु.
Website of the
देख्नुहुन्न सर तपाईँ एनजिडी जानुभयो भने देख्नै हुँदैन.
No, website means e-courts website.
त्यसमा आउँछ फ्यामिली कोर्ट केस.
Nothing is shown.
The whole establishment database is there.
त्यो चाहिँ हाम्रो हातमा थियो कि
ई कमिटी
E-committee.
what they said.
उनीहरूको इन्स्ट्रक्सन्स आएको छ लाइक डेटाबेस इज नट उनीहरूले डेटाबेस हाइड गरेको छ बट वी आर डुइङ द अपलोड अपलोडमा बन्द छैन अर्डर द देश वान फाइन्ड इज ई कमिटी लेटर अनहाइडेड दे अनहाइडेड.
No, maybe because of the problem, because see, High Court and Supreme Court, they are quite clear on how to write those judgments, how to hide it. Maybe there are so many trial courts. See, I'll tell you an example. I've been to a different program not relating to e-courts at NJ, and district judges and additional district judges asked me, what is CPC? They asked me, what is your job profile? I said, I am CPC. Then they said, kya hai? Then the other one is, next friend was there, who was about to speak, but I spoke and said, it's under e-courts project. He said me, what is that? And the other fellow somehow knew his friend or some other officer from the same state. No, it's e-computerized. And oh, वो तो हमारा OST करता है. So see the level that is there. So maybe people write whole lot of names in their POCSO judgments and put it up. That could be the situation which can be only fought by saying, we'll hide this. That could be the reason, but that still does not mean we cannot upload it. If we are doing that, fine, well, fine, because one fine day, things will change, they'll improve the systems, and if we have not uploaded it, then they'll again ask us to that, say, you uploaded it since this year. Because I'll give you an example that most of the digitization in the entire country did not occur according to the SOP of 2022. Then by 2022, most of us have digitized so many records. Then in one program related to e-courts process, I said, before 2022 there was no these guidelines. So the way we have digitized is different. They said, we don't know anything, you do it as per SOP. So this is how the projects are pushed also, otherwise it won't reach its actual goal. So they will not care what we have done or what we did. They want us to do according to what are the new guidelines coming. More so in this computerization, because every now and then things are improving and they are trying to change. What seems today, what was very good few years back seems very old today. So that's the reason in digitization and computerization, everything is going to change very fast. So we will always be doing some extra work, right? So, but we can minimize that by using our own brains or at our own local level. We can always discuss the issues if we are having. So this is all about equals project. Next we are coming with, I think Mr. Tashir Abdan would be aware, Honorable Justice Bhaskar's court is paperless. But with all our basic equipments we have done, we still have not got those. So once this fund comes, then at the lower side of the lawyer's side also, I am thinking of giving Wacom only, but let's see how the fund comes up. But not only on the bench side, on the bar side also we'll be improving, the interface, the computer interface. And one fine day, if I can say, I was Justice Bhaskar as a paperless court, he would be having his own problems. The problem is from I think most of us also, when it started, we were not very much happy about using computers and all. And rightly so. See, I am 42, I am quite comfortable. Still, I am requiring a need to read paper only. It's so difficult to correct it in the MS Word itself. When you read in the paper, you find more of your mistakes. So because we have not been tuned to that, we did computers in school or maybe whatever it is. Since college days, we got little bit more hand on the computers. There were lots of cyber cafes. So that's how we learned. But a day will come when, if you see the employment notices of High Court, almost all the jobs are asking for computer certificate. And it's been amended that computer is required. So these things will come. So someone having computer knowledge is going to come in future. But for us still, it's quite difficult. And if someone is 58 or 60 years old, like we have very senior lawyers who did not use computers in the past, it's really difficult for them. So there's always this discussion. The Lordship would want everything computerized. But the one problem came up was that in the paper book, Lordship is using the PDF version, whose page starts with 1, PDF reads 1 as the first page. But there's a practice and procedure rules in High Court, it starts somewhere from other page, and ABCD is there for synopsis or whatever it is. So it's not matching. The lawyer is saying, Lordship may read page number 10, Lordship is at page number 16 or something, right? So I said to Lordship, can you tell the lawyers to change the page numbers? How will you change in the system? No, they will not agree, no. So these issues are going to come up. But yes, we are working on changing the rules in the practice and procedure, that everything ABCD should be done away with. And page 1 means 1. Whatever is, whether it's cost title or whatever it is, right? I do not know whether that amendment will succeed or not, but we are working on that. So there are so many things. What was your question, Joel? Okay, that one. That's a very often asked question. Even I used to ask it. Because we do not have that computer system at the moment in our courts, which can do everything paperless. We still have to print it because our monitors are not touch screens. You cannot do anything out there. So very soon we will do, but not in all cases. Probably will in the trial courts in NI Act or family cases where less evidence is required. From that point we'll start. Commercial court is mandatory. So like the commercial court also deals with arbitration appeal, I think. So in those cases then evidences are not required. So these are going to be paperless. Very soon it will be, we'll try, and we'll need support from bar also because we have to, there's no way out. Because everyone says Sikkim having just a few cases, why you all are so back? But they don't understand that, that things, we are not a different species, The lawyers have studied the same law, the judges are the same. The system and the situation is same. The only thing is our size is not enormous. That's the only difference. So the difficulty which other states face, we face it, except this enormity. To distribute hardware, we have done everywhere. It's so easy for us. But for Allahabad, to distribute hardware is also different. We don't have that problem. But moving ahead, it's quite difficult. If you see some of the states like Kerala and etc., they have done very well. Most of the courts are digitized. But the thing is, they have not followed the courts project. They have kept it at the side, but they directly say that we are not concerned with your project. It's a too old type project, which they say, and they have their own softwares, their own in-house. Their computerization is there. Even e-filing is their own. If someone wants to file through the e-filing given by the Union of India or Supreme Court, whatever we may say, that's their wish. But since they developed their own, most of the lawyers there use this state e-filing system. So as a project, it's going on in the states also, but they are more into developing their own system and moving ahead on their own with their own plans. And somewhere it's rightly so also, because one fine day, as I said, e-courts project is going to end. If we depend on this till eternity, then we are going to be at loss. So we also need to develop our own systems. In fact, if I may say, I get at least 3 or 4 calls every day from some private firms saying that they have developed this software. They have developed very good softwares. But we are on the e-courts project. So if the state can give us fund, then we can do that private. But a problem with private firms also is that once we are dependent on them, they will start extracting money. Initially their software will be standard priced, but in years to come it will be very high. So everything is about money. We could have gone paperless long time back had we had the enough fund from the state, because there was no fund was asked from the state. Still it's difficult to get it, but we will try this time getting the fund. Of course, the center will be giving for paperless court. High courts, commercial benches are going to be mandated paperless. But in that gap, we have asked for those equipments for all the courts, for the entire state. So let's see how it goes. Even I'm afraid of the thing that is going to happen, because maybe it might be difficult to handle, so that those things comes. But yes, it is going to be. No, the Madhya Pradesh, state of Madhya Pradesh has given 256 crores to High Court for digitization apart from e-courts fund. So some of the states, they are taking initiative on their own that yes, we should give it, and they have used lot of equipments. Never heard of. Their servers are directly imported from USA. So this is the level which they are. Why? Because they had 256 crores given in a last financial year by the state government. Of that size, 256 is still not very big or not very small also, but something with which one can do much. So it's 80% about funds, okay, 10% about implementation, and 10% about how we accept that. So I think tea break is at 11:30. 11:30, okay, we still have time, right? Artificial intelligence. Now I don't want to speak much on this. We have some learned lawyers. Mr. Raptan has been out of the country also, yes, in so many things, in different perspective, but still, traveling and seeing things gives you much more experience than sitting at one place and opening a book and reading. I have experienced that. I have stopped reading it. Some people ask, why don't you write a book? I just say to them, I have to travel before writing a book, and we haven't been much places of India also. So what I meant was, once you travel and see something, even in our country, if you see, every place you go is different. You get to learn something. So AI, I don't want to speak much. Let's hear now. In the AI, in the e-courts project, in this phase 3, which is going to run for the next 4 years remaining now, wishes to introduce AI. Their basic concept of using AI is it could be given to lawyers also, some kind of application, which will assist us. Let's say a lawyer has filed 5 judgments before me in a particular case during argument. I'll have the citation, I'll have the case name also. The idea of e-committee is that if now I have to read all the 5 judgments, right? At least even if I read very fast and it's on average basis, then it will take at least half an hour to 45 minutes for an experienced judge to go through what the judgment is saying. Lawyers would file even if it is not matching, even if it's not a precedent exactly, they would still file. And we have seen, judgments of 10 or 15 judgments being filed in a synopsis, a binded form of synopsis. So I should be able to put the judgment and put the facts of my case and AI to guide me whether those judgments are applicable. Now, one problem that would come with this is, can I rely it? The biggest problem at the moment of AI is, can we rely it? You can just open ChatGPT and ask something. Sometimes it says so weird, and it's ChatGPT version 4.0. Right, but I got to learn one thing from, recently there was a Viva of the computer card. He gave us, which I will talk about, what is AI, he said. So the problem about AI is reliability. Can I rely it? If it says no, the 3 judgments of the lawyers is absolutely not matching, it's not at all a precedent, it does not match with, can I just keep it away and say thank you? Or do I have to read it? If I have to read it, then there's no point. But this is the idea with the introduction of AI in this third phase. In fact, most portion of the fund that is being invested in this third phase is on AI. Some kind of app or whatever. Let's hear from on this AI. Another problem of AI is how to have a system to appeal them. All AI will be same. If you are using one kind of AI, it will decide similarly at all levels. So what to do with appeals? What will the lawyers do and say to the so that is extreme form of legal system being manned by a computer, because there is always an argument, can it replace a judge? Till date the answer is no, but the scientific community is still positive about it and says yes. But that brings to another legal problem, which I said, is what about appeals? If it will always be upheld, or if it has been dismissed, everyone will dismiss it. So that's another thing. That's a very extreme one, which may not come in judiciary. It has not happened in foreign countries also. But let's hear about AI in the judiciary. What is your perspective? With the computer people, we can start. We can lead the dialogue.
Sir, I read somewhere, sir, Maharashtra, in Mumbai, I think they are trying this AI, some judicial officer to write judgments.
Yes, sir. We can write.
Yeah, what they do is like they enter the case information, the sections, and then few facts of the case. So based on that facts, what AI does, it searches database, it searches all the judgments which are relating to that particular case, and then it gives an idea about what judgment to give. It will not give the judgment, but it will just give an idea about what kind of judgments should be given.
Yeah, to that extent, it can be used. In fact, the present AI, when it comes to research and etc., is up to that level. It still does not have. Let's try. There's Copilot. Microsoft one is Copilot, right? Like ChatGPT. I think ChatGPT once wrote a petition for Kerala High Court, including naming the judge. So I don't know, Mr. Rabdin can say whether this is a mandamus petition or not. So if these are not being given, then it's quite easy, no? Then it's quite easy. I think what happens with AI is, once we know, like these petitions, etc., as a lawyer, if petitions are there, and if once he finds the petition which is being given to him, at least this framework is correct, then he'll always use that. Why to write, why to type so long? Let's see. Read petition under Article 226. ठीक है Mr. Radha, 226 mandamus. And the petitioner herein and bring before this honourable court the following facts and circumstances, praying for the issuance of a writ of mandamus under Article 2 to the Constitution for the enforcement of fundamental rights guaranteed. It's perfect. You can only issue writ or writ jurisdiction when is your rights, fundamental rights violated. So the first paragraph is perfect. The honourable court has jurisdiction. This format we have, no? Yes, they have it has to say that, the format of jurisdiction. Provide a succinct yet facts it's not giving because it still does not know the facts. Okay, it cannot create its own fact. Grounds of relief. So, for a petitioner in person, it's quite helpful, right? But for lawyer also, okay, give this, and maybe if you give the facts, it can do more. So what else we can type? Judgment. Let's try. Hasn't? It will definitely, if you can write 3 to 226, why will you not write back? BNS is quite difficult. Listen for. Let's write IPC and I'm quite sure BNS it will. I think it will still read correctly. But it gives a disclaimer. Remember, it's crucial to consult with a legal expert or a lawyer experienced in drafting.
Disclaimer.
I think it's because of net. I think it's no, most of the things it's giving, at least for reading purpose, or if you need some source, you can always check that if you have time. If you want to read something where, just like last time I had to write something on these new laws. I had to prepare it, and then, I knew, but book was a very big book. I had to read every page. What I did was I used ChatGPT and said, what are the changes? It gave me entire. Now from using that, I could go into certain pages or certain chapters of the book, which my work became much faster. I need not, read the entire book. And which book should I call from the library to know more? Right. So it does help, but it's not that we can base at the moment we cannot base our work completely on it. There cannot be a blind reliance to this. I think this is not of network. Let's try the last one. See, 437 it gave itself. I never gave that input of 437. Right? By dangerous weapon means, while I do not intend to undermine the seriousness of the offense, the judge would be impressed. It is pertinent to note that the accused is entitled to the presumption of innocence. So it's a perfect one. I haven't seen this in court also, to be frank. Till then I was there. It mentioned two very important things. Seriousness of the offense, which the court will always look, but still reminding the judge there is a presumption of innocence. Right? It is pertinent to note that the accused is entitled to the presumption of innocence until proven guilty. Furthermore, the offense is bail. This is wrong. See why we cannot. Is it bailable 3 to 6? So we cannot absolutely rely on these things. So we must, at the moment in the AI, have some kind of knowledge that whether what it is saying is, or we decipher things whether, if I would not know whether the offense is bailable or not, then lawyer would keep it and the judge would on this sentence reject the bail. Oh come on, what you are saying. You would not listen further. Unless the lawyer can. It may not be in every case, but it is speaking from somebody. It is learning at least how a bail petition should be. So these things improving one fine day is going to be used. But as I said, one of the Viva, when one question was asked, tell us about AI. He said that there is still no AI in today's world. And his reasoning was, for AI, okay, let me be specific. The question asked him he was some expert in artificial intelligence. His course was for that. And he was asked, what can you do to make, what can you develop for High Court which can be used as an AI? He said that I cannot make much, because for AI to succeed, it must be having a huge data. The more data you fit, the more better the AI will be. High Court does not have any what data you will have. Just the judgments is not sufficient to create a very good AI. In fact, he replied very well. I liked his answer. I do not know about others, but he was absolutely correct. He's saying that today's AI, which we talk about AI, is not much AI. Now, I do not know. Have you ever thought that traffic light which they are saying is AI? I don't think so. It may be reading the number plate, and that the police in the Siliguri police have handheld devices. Now we are seeing the traffic light. I do not know. Let's see. And you know, one of that circular, what it says in the end. If any problem arises, kindly meet the secretary or something. So I think a lot of that thing is going to come up. Your everything is correct, but still you will get an SMS saying that your so and so has failed. That is why I think that it's a good thing, but still I don't consider it to be an AI. The only purpose that it is doing is there, reading the number of vehicles. If it is that intelligent, also reading number of vehicles and deciding how much time a particular side of the road where vehicles in the road should wait. I do not know whether it will do that or it will have a defined time of, let's say, 1 minute to every side. We'll see that. But still, just capturing the, maybe it has more, what we have heard is that much. Just capturing the number plates is, I don't think it's AI. We have already fed the data. It goes and links with the database in the Parivan website, and from there it sees it, how much it is updated. So that young boy's view was, the AI still, we are just calling it AI, something to be intelligent. As we are, though artificial, then it has to have a lot of data. And then, because it is not a brain that is made with neurons and all. For humans, I do not know whether that could be true or not. It's medically still argued whether you are born intelligent or you acquire it. That medical people can say it properly, but if artificial intelligence reaches one day as like our intelligence, then it would be a myth to say it is born, we are born with intelligence. Because if you see nowadays, most of the children, I have not heard any parents saying my child did not come first. Whoever I have made known, my child came first or second, everyone is coming first and second. So the study system is very good maybe nowadays, right? So still, it could be arguable whether you are born intelligent or you acquire it. Because even if you are born intelligent and yes, some talents are different, like in sports and etc. The way Sachin Tendulkar would move his hands, no one can move it. And those things maybe are called talents, but intelligence is something else. So AI needs a data, he said. And we have very less data to give you instantly some very good thing about AI. So things will come, and I think it's more of a machine learning, though a component of AI. The AI's basic thing is, you don't tell it what to do. It has to learn itself. That's why it is giving this one, billable. No one has told this ChatGPT that this is not a billable, non-billable offense. Somewhere someone has told billable, but still it's, it has to say itself from why it is bringing this billable nature in this place. It is trying to say something by itself. Gathering the data which has not been given. In AI, you don't give specific command to do something. There are commands, lots of given, but it does not give it to say to do something. Ke garnu chai timle yo sodyo bhane yo garnu bhanera chai AI ma hunदैन. It will from all the given data try to identify itself what should be the answer. So that's why it's giving this answer. It brought a wrong answer of billable, but up 3 lines were absolutely perfect. And still in AI, every time it will write the same thing. Every time I type 326 ko bill, it will write the same thing. So it's still not developed to understand, to give you a different write-up to a similar question also. It's still not understanding that. It still understands one question, having one answer. So see, even ChatGPT, which is very famous, I think it is one of the most advanced. I used Microsoft's Copilot also. It takes you to website. If it doesn't know the answer, it takes you to somewhere in the website. This does not take you to website unless you specifically ask. So these things are going to develop. We can always use it, right? I've used it in a few things, I'll not tell. But we must be very careful. You can use the idea from here at the moment, but not copy paste it and realizing that it is something else and or written by someone else. Now, still Mr. Jangpo is there, our additional Advocate General, tell us something. What's your view on it? We have never heard lawyers' perspective on AI on this side.
So far as lawyers are concerned, it's very beautiful because the SSC online is also a typical form of an AI, and a very rudimentary, I would say, compared to when we were using the SSC online in 1994. It was a DIX, it used to come in the DIX with the key USB form. That is the one was there. It got updated with the online. Online came from post 2006 onwards.
Yeah.
So now it's so beautiful that if you put the chat GPT keywords, like in earlier SSC in the hard form, there is a form of keywords. If you read from 1980 onwards to 1990, in all the SSCs there are keywords, search engine like the books also. And now if you use keywords, everything comes on.
Yeah, that will bring up a more refined argument or your petitions, etc., which will help the court
Now
also.
in the text form, it's more difficult because the rulings which has been ruled out by the Supreme Court by a larger bench, you get a red
Yes,
mark.
yes.
But in the online, it's not there. In the premium, it's there.
Okay. So that's what I told you. It's all about business also somewhere. A premium might be costing
So
high.
like
Right?
last time in the 370, the Supreme Court, when the argument was taking place, the Honorable Chief Justice used the AI to record the submissions of all the lawyers. So it was being flashed out as an only when it was being updated.
Yeah. The translation software also which we are using, it's some kind of AI, but very rudimentary still. It still does not. Still leave granted. It says there was in Hindi also it says chutti स्वीकृत किया. But once you change that, no, leave granted, like once you change it and correct it, next time it will not say chutti स्वीकृत किया.
As we were speaking, Justice Oscar was giving us a lecture on the translation. So they are coming up with a beautiful AI. Last time it was online. I was, many of my friends were watching. So then he was saying that there is a new version which will be coming.
Yes, yes. If you see website, if you have seen, we have translated. We have not uploaded all 100. We have recently translated about 25 judgments. We have translated on our own using the software only, Suhas software, and to a more or less extent, it's okay. Compared to many of the Hindi translations, where in the middle they are using English words. Okay. So, but soon we'll be filling up the post for translation also.
Like when we were doing matters in Supreme Court or in High Court, the regional language has to be translated. My friends in Delhi and all were using the local lawyers from, suppose it's coming from Gujarat, the Gujarati lawyer would be asked to translate. A person who's coming from Kerala and they have a translation to be done from Kerala's language to English, the Kerala lobby would be used. And now
Yes, yes.
the translation team has gone out and the AI has come out.
The only thing that remains still in the translation is someone, we studied our own second languages, whatever it was, but still we have forgotten. And we need someone who, because some, let's say Nepali literate who has studied Nepali language at least up to graduation or post-graduation would find many mistakes in these translations. We may not, right? So, but still it's not something to be pointed out that, see, your judgment is, the meaning is, because and it's more difficult in judgment, the meaning which it gives must be correct. That's the only issue in this translation. Now the translator would come from the language background. We have not found anyone who is equally good in law as well as that language. That person is required actually, so that the meaning of the judgment doesn't change. Sometimes the line changes it. I have read it so many times as waiting whenever I get time, and so I have to make certain very important changes. But when you don't have time, we are uploading like that, because everyone asks number, what should we do? They asked 100 judgments in 3 days at one point of time.
Literal translation from Nepali to English are used in Nepali. It's next to impossible.
Yes, yes. So hopefully we are recruiting who could vet it. Main is vetting. So process re-engineering, we all know about that. N-step is one of that. What could be more, Acha, the new act, the BNSS, I think, it allows all form of delivery of summons through electronic means. You can send email. It has not said WhatsApp. It has left for the state government to decide what modes would be used. But I think we were using this even when there was no substantive provision, right? Because someone being not found, in NIACT especially, we did send emails whenever the parties provided it. And at times, there's no issue of delivery. The only issue that remained with use of electronic means in the previous law was that how would you prove it's delivery or not delivery? You have to call and examine process server, right? So like WhatsApp ma pathai bhanda kahi lekheko chaina WhatsApp, I cannot call and someone and examine someone and say it's delivered in WhatsApp. Even though there was blue tick, it was still not recognized. But now I do not know what the state would do. Our state would do what others have done. Usually they do that. So I think that Surat is also. I think all forms of electronic should be at least allowed there. Whatever the court uses it's their thing. If everything is allowed, so that because some people they just want to know when is their case. They don't want physical summons, so they don't want processor to come. WhatsApp would do for them, or SMS would do. There's so many such people just to give the information.
WhatsApp is more recognized compared to emails. Because people think there is no one, I don't think anyone is there who doesn't go through the WhatsApp. Or who doesn't have a WhatsApp in his phone.
Yeah, it has left to the state government to decide on what kind of electronic delivery of summons. It even says warrant, but I don't know how warrant would be done. Some specific device might be required. It's recognizing this form. So the processes would be quite changing. Maybe N-step would also. N-step has not been so far since it began upgraded. I think. Upgraded in a sense to do something substantially different than how it began. Right? Of course, versions may be there. So N-step may develop in future. And process automation, if we see that the CIS actually we use only very little percentage of CIS because as judges we don't have time also. It has all those templates etc. And then it would be it's not actually an AI, but it would be giving the format of summons if we we do not fill witnesses name, do we in CIS? But there is a provision for it. So if the more data we fill, the more automation ease it becomes out there. If we have filled the witness's name in the CIS, next time the person who is producing summons there just need to select the witness. Templates are there. It actually eases the process, but still till date we haven't been able to do it because, as I said, the more comfort is in the previous format of software. Just change the name there. That seems to be more comfortable to the ones who are still working with it. But if you do not use this feature in CIS, next time a new feature might come and it will be burdensome. Many things are there. Witnesses list. I think everything which we do on paper is there in CIS as far as I know. Right? Except a few things.
I think WhatsApp now will have difficulty because the Bluetooth modification is being done away with, right? People can put it off. So then what is the proof of receipt again?
No, and state may write these are included and the court may. Court may seek for such proof as may be required. Because if I feel if they restrict it, then one finds that WhatsApp would also be working it. If it's not there at all, then we ask what means to be used. Let the judge decide among them what has been given. Sometimes let's say people have stopped reading SMS. WhatsApp at least they would read. So if we stick to SMS, so leave the all options open and let the court decide which one to use. We'll use all, we'll exhaust all in a particular case if required. Right, if in one area WhatsApp works, then our concern is the person should come to the court. If the person comes, whether he got through WhatsApp or SMS or whatever it is. Now still the country might say Telegram. There might be guidance from Union of India. That is how the nation works at the moment. To all these states saying do this and not WhatsApp, Telegram. That could be, and they will again brainwash what Telegram. So of course it's good, but I do not know why Indian products have no consumers. Though we speak a lot about we accept don't. This is also I don't think it's Indian. WhatsApp is not Indian. Even though Telegram is also good. I have Telegram, but I think some of the groups in the committee or whatever they force us on Telegram, so we are there. But I do not know. Some economist, Mr. Janpa as a lawyer would be arguing on a whole lot of things. May be able to tell why Indian products don't have our own consumers. I think the export is more of some of our commodities. Paperless role of NIC. NIC has a pivotal role. It's a big role But still, it's not in the forefront. In most of the courts, some of the employees that are given, at least in High Court, we have 2 from NIC, the employees under e-courts project. So it's a pivotal, all the internet networks is seen by NIC because the government thinks that funds should not go somewhere else. And NIC is quite robust. It's handling. Oi. NIC, it's doing a pretty great job to my understanding, looking at the vastness of the country and an institute not manned by many, even if you see here, few people are only there. But yes, due to in the districts, the internet line usually does not work. But in the High Court, I have seen that it works quite well. Despite now we are having I think 36 now our bandwidth. 36 or 35, I don't know, it's inadequate for us now. We need at least 100 Mbps. So I just came in mind, if so would be, because we have not been invited to that meeting regarding providing of internet connectivity to the courts. Is there in that meeting? It's on 27th, called by Chief Secretary.
I'm not there, but yesterday I was.
But it's quite surprising when the court is involved, neither law secretary is invited, nor anyone from the High Court. Because our bandwidth requirements are.
I can speak with the Chief Secretary, sir, because tomorrow we will be coming back from Delhi. So I'll ask the staff officer to call someone from the High Court also, so
Yes,
that
yes.
you can join the meeting. Last time I apprised the meeting because in the last meeting I was there. So I told Chief Secretary, sir, that I think we should have someone from the High Court also.
They have asked us the details, but what they will do with the details which we gave, whether any positive outcome will come or not, we don't know. They have said your bandwidth, present bandwidth and bandwidth requirement further. We have increased our bandwidth, but how that will be done, whether it will be given, we are not sure.
Because yesterday also there was one meeting with the Home Ministry regarding this implementation of BNSS and other laws. So from July onwards, I think investigation will also be as per the BNSS and
Okay.
it will be digitized. So Chandigarh has already developed one software called e-Padtal. Now they have tested it also, and all the IOs have been provided with one tab. Now they are doing the investigation with that tab only, taking the pictures, uploading it. They have a cloud server. All the things have been season things have been done in the tab only. So now the ministry wants all the states to look at that.
Okay, sir. In any case, if you happen to be in that meeting, then we have sent the data. What's our requirement? So.
After tomorrow, I'll ask them to call someone from the High Court.
Okay, sir. 27th is the meeting. Today is
Today is
22nd.
22nd, so there is still time.
Last time, Madam Denka had gone, I think.
Yes, she was there.
So MOU is there. Okay, data security, importance of data, concept of data as an asset. As we said, why data is an asset, Probably one of the reason is developing this AI only. The more data you can take, now we give data everywhere. We give, even in shops when we are going to malls and buying something, giving our mobile phone is data. So in the name of feedback, phone number is there, email is also there. Right? So in times to come, everything will be with everyone else. So the importance of data is to that extent. Now how do they? Now see, once you do something in a particular, let's say you have ordered a food or something, your number has gone to all those enterprises which are interested in or which are doing delivery of food or some kind of link with food. That is the direct sharing of data. Now some other who are not interested in food, but might be interested in which places you go. Let's say, we have traveled somewhere on a holiday to one place and you purchased something, some food there. The food company would be obviously interested that you visited KFC. It means either you are a new person who has visited there and would like to visit more, or you are a regular visitor. These companies need to know all this about you to go ahead, right? But someone who would be in the, let's say, app such as Make My Trip, which is a tours and travel kind of business, They would be knowing which place, like to know which place you go. So some indirect sharing would go there also. So once you have, I do not know whether you will get it. The reason why previously we used to keep two numbers just for having two numbers. Now the thing is, I keep two numbers. I don't give one number to anyone. Somehow, despite being very strict, some of them have got it. Because in that number, you need not worry who is calling or whatever it is. We have not given it to any important person. At your official number, even if the unknown number comes, either you have to pick it up or check in the true caller who is calling it. Some might be important call from someone. No? So one way of avoiding that giving number is keeping two numbers, not just for the sake of keeping it, but using that number to all those your shoppings. Now they ask for mobile number, what would you have to give it? Okay, now give your number, that number which you do not use for calling, WhatsApp, etc. So that in that even if call comes, you need not bother from whomsoever it comes. It is obviously a spam call. But once you give, it starts coming again and again. So it is data sharing. It's as simple as that. It's just a use of common sense. You give number to one, and email, if you have used email in some kind of purchase or whatever it is, you will have a lot of spam mails. Not only from the one from which you purchased the product, but from so many which you have never heard of also. And one of the options that they give is to unsubscribe. You unsubscribe 100 times, it doesn't work. For some days it will work, but from some other route, again your email reaches them and they are legally prepared. But believe me, they are legally prepared to argue anything within the law to say that we have not violated you or anything. They just don't mind these data without having any kind of experts, of barring a few which are on the face, prima facie scams also, like this one, loan app. That you remember Sandeep, your processor, Sandeep Subbana, what he had done. Now that's any episode is over. I don't mind saying that because he did something which he should not have done. He took a loan from some kind of app. God knows when. And HOD's name, I do not know, he gave mine. I thought there could not be an issue of app because, thing related to app, because that I was there in North till 14 permanently. After that, I was roaming here and there, North and Gangtok. So I used to get a call saying your employee has not paid the loan. Then, okay, initially I thought it could be genuine thing, okay, I'll tell him so and so. Then one fine day, again the fellow calls me and says, initially I didn't know who Sandeep Subba is, I forgot. Then later on he sent me a photo on WhatsApp, then I saw his photo. Then he was Sandeep Subba, a known employee of my office. Then again that fellow, and it reached to such an extent, he started using foul language on me. You are not recovering loan from your employee and you're not. Then it was too extreme, then I called up the district and session just then and said your employees, I think gave my name, my number also, and so is coming. So in the end I called him to meet me also. He came and why you are doing this? He said I have already paid. Now he is thinking he paid principal. But you know what was the interest rate? 25% or something. So these are all scam loans. If you remember, there are so many. If you just go to App Store, they will give you instantly 2 lakhs, 5 lakhs. Maybe he took 2 lakhs or something. Interest rate 25% something. He's saying I will not pay that. So I'm saying, why did you give my name? I'm only concerned with that, whether you pay it or not. Then he's saying I didn't give. Then how can what he said, and that could be very true, 90% true. Now, I didn't ask him that on what name or how he had saved my number, but something he had saved in his mobile phone, my name. So this, I've known some people in the villages who, sometimes call me and say, this is they are doing, what should I do legally? In his case, he is saying his phone numbers were taken. So from there, maybe how that person identified, because once I was Jane North, right, and he was, I was handling that office as head of the office also, he was there. So maybe still that old name was saved, something kind of like that. So from there they could recognize that this is the person whom we should call to pressurize Sandeep Subba. And from villages, I've got, many people are into these scams, these loan scams. They'll get instantly 2 lakhs. But the They do not know what is the meaning of rate of interest. They think they'll have to return 2 lakh, and some people have been flooded with nude photographs of them who took the loan, and those photographs, the head is different, the body is of someone else. Photographs are in your mobile, so it's obviously hacked. So these hacked, in a sense, these applications we have given permissions to visit our galleries. The moment that is our contacts. Now the common people would not know while accepting the terms of that app. So probably that happened to him. He may not have been given my name, but somehow the fellow identified that this is the person's. And this is one case. Another one, so many known people of me called me and said, what should I do? The only question is go and lodge FIR, right? But they are very afraid to lodge FIR because no one wants to let the world know that you have taken a loan from such an app, and another about that nudity which is not yours, right? Another thing also, it was another case. I was then in Gujarat, and one of my known friend called me on behalf of someone and said, this is happening, someone is flooding with threatening to give the world the nude pictures. Very well morphed one. I knew the person, so they sent me the photograph also. I could see the morph. One of the photo was very well morphed. They matched it so well that the angles, etc. And then that fellow said me, the caller is threatening to give this nude photos to this particular number. I said, who is this number? And among all those contacts, the person who was the victim did not. She was willing that the whole world let it be known that these are my nudes, but she did not want one specific person to know it. And that fellow was threatening to give it to that person. How they are doing it. So I don't think these small companies also are just for the namesake being less than we had before, Jamtara, running from someone's small room. They were running then even without technology, with their own brains. Now if you match that brain with the present technology you have, from a small working space full of computers you can do anything. So I felt this is some kind of analytics, which there are so many analytical softwares that you can buy online. Maybe the number of times the person had talked with that particular person, the duration, right? All these things could analyze that this person is more something of it with this person. And as I told you, that scammer correctly picked up that number and threatened I'll send to him. And that particular lady had no problem with the whole world knowing it, but this person should not get these photographs. So it's not a small thing that's going to happen in the near future or something kind of like this. We came in the context of this data. So data is everywhere. Our half of the data. As a judges, we need to be more particular whether this will be a kind of acceptable thing because we cannot remain as a hermit which they use. Hermit may be in the era of when judges used to wear that different kind of status then. Now we cannot be that unsocial also in today's world, and we need to use technology also. Because as a judge, I have Instagram, I have Facebook, I tried Snapchat also. Because I feel if you do not know this, if some case comes in my court, what the hell will I do? Tell me. If a judge who has never used Instagram and there is an argument about Instagram, how DM works, how you can unsend the message, what is a meaning of story in Instagram, what is a post, what is a reel, how you can add, what do we call that, filters in that. If as a judge I do not know these things, I still feel I am knowing much less. Don't know, what the hell, first of all I'll get bored, I'll get lost, and I'll not write a good judgment. I have had this problem with a case relating to ATM machine. I tried to read it, but I didn't know how ATM machine works. I was asking she continued that case. I was lost all of the time, and I had to ask the witness a lot of questions to understand how that works. He would generally say in a particular witness coming, I posted in my story. The witness will not say what is story, and which side of the app you will find. As a judge, I should be knowing it. If I don't know it, I'll have to ask that witness. It will sound foolish also. The witness might think, what kind of fellow is going to judge my case, who do not know on which side of the app the story is. So as far as, so from that viewpoint we cannot complete. So opening Instagram means I gave certain of my data. Now if the standard of considering a judge to be, what to say, of having integrity remains, you should not have social media, I would still not agree to it. Because times I've seen that we have to move with time. If judge doesn't move with time, then who should move with time, including lawyers? So data, we will have to give it. It's going away, it will be given, and it's the gold. All the computer companies earn on data. So many apps, why they're coming up? It's all data. Even it has everything come to our hands. Even things like investing. You need not have a broker. No, app is the broker. If you are good at using apps, if you are good at researching online, the apps are far more better the way it guides you than the brokers. And I have one, so we should know it. These cases are going to come in future. We will be dealing with this, even including murder cases or whatever traditional forms. We will be dealing it from the point of view of electronics only and evidence act. Yeah. So there's no side being about using this thing. We have to use this. Lawyers must use it. They must know everything more than the judge. So maybe the things will change, in times to come. What is ethics? What is integrity? Should change to my understanding. You can't judge a person because he or she is using Instagram or Facebook. Someone might judge. Many may judge. Oh, the fellow has Instagram. But I guess, of course, we have very restricted accounts where only known people are there. Even sometimes staff's request comes, we don't accept, but we don't delete also. For some of the topics, with the permission of director and deputy directors, I would call someone from that side to speak on it. Okay? That would be much more better. Like Yolan is there. Mr. What's his name? What's his name?
Mr. Dixit.
Dixit. So two of you will kindly speak on some of the applications, which they are more frequently using. I think, notwithstanding that I am the resource person here, it does not mean that still I know more than the ones who are actually working on. So e-filing, e-payment, they actually confront with many of the situations or the grievances of the lawyers. So, Mr. Jointly, any of the topic, Yolan and Dixit. Or Srinkala also want to do? Why not? Dichen. Because I am telling Srinkala because I don't know Dichen much. She was there since I joined. But you are system officer there, right? Dichen. System administrator, okay. And Sarah, where is he? Sarah also needs to be brought to some happening places. So basic IT infrastructure of a courtroom and a court complex as per the policy and action plan of ECOS project phase 3. So there can never be a uniform set of infrastructure or computers that was there a few years back or that are there today or what can be. So we cannot, there's no specific formula that this much is the requirement. It depends upon the size of the court, the nature of the court, the amount of network facility that is there in the court. So among the basic IT infrastructure, the computers are a must. So Mr. Rabden is also there, Rampo Serpa is also there. We have provided that those screens on the trial courts on the other side for you to read that. Whatever is being typed in the other sheet, right? But is there something else which, from your perspective, more is required for ease? Because we don't get these opportunities to talk. We are given these screens. Maybe someone is feeling, this is inadequate. Or many lawyers are there. Dr. Doma also, with a long-standing practice, and Jola also. Oh, I'm so sorry, I forgot your name. Sachina, yes, Bivai Sutta. Maybe that we have given these screens, or you need larger screen. That thing can be said. Even I am saying it's too small. Or we have given bigger one.
You have given bigger one. sir, but few of them, they were damaged during transit.
No. When? Transit on your part, I guess. We will not take the responsibility. So that was long time back, not the recent one.
Recent months we have not explained.
Okay. Screen needs a bigger. That old screen is there, no? The small one. That's which was initially installed. So that could be one, right? What else we can do for lawyers on that side? On the basic infrastructure. Of course, bar rooms we cannot provide, but to the bar rooms. We are trying on our front, when if the court goes paperless, then to give an equivalent system. I think one company was there, which is not Wacom, but it's an Indian company, which builds monitors like that of Wacom. Forgot the name, that is quite cheap in terms of pricing. So we are thinking, we have a plan, I am not sure, that to give that same system on the other side to the bar also, from where they can use the screen touch.
So we need power backup, sir.
That's power backup. UPS I have been asked every time, but for power backups, we gave that E-Coach gave, not we. E-Coach gave that solar, that big inverters, that what do you call DC sets are there.
Yes, this is a
That should be sufficient.
power backup for Gangtok district. We have only 5 kilowatts, but the actual requirement is around 25 kilowatts.
No, understood this one. If the DC set comes, definitely, because nowadays they are not providing DC
No,
sets.
the DG set is enough. DG set is 62.5.
Okay.
The solar power.
No, and where you have used this solar power? For every room.
No, solar power not very good. Only for the computers. And
Yes, only for computers
That is
itself.
also not sufficient for Gangtok. Other districts, I am not aware, but for Gangtok it is not.
Not sufficient. But for waste, I think it's sufficient. Where is it?
Depending
Jimmy.
on what.
Huh? No, is it sufficient? For computers only. Don't think about the entire building or wherever it's supplied. It has been supplied to some points where it was not required, because initially even we didn't know that. Computers, matte chalnu to books and
additional code size, but we have a
no, don't extend it to additional code, because if you extend that, then it was not provision for then you will be overshooting the requirement. In future, if it comes, we can. I think for additional code, solar has been earmarked. So don't give it to additional code at all cost. And one more thing, as I said, it's recurring expenses. District judges can take note of it. You can requisition fund from the state. And whatever the requirement is, you can do it from there. And don't think that solar is it's just a backup energy. It's not a primary energy. So if we mistake solar to think that it's a primary energy, it will be wrong. And one fine day, those panels are going to stop working. We all know. Batteries are going to drain, and replacement is district. So it's good that we have solar, right? But still we have not. Most of the times we are asked how much electricity bill you saved. Okay, but we don't know how much we saved. And it's quite contradictory what they said. When this solar system came, they never told it was only for computers. We thought it's for code. Even I thought it. But now they have started giving this dialogue that because what Nagaland said, it is inadequate. Then they asked them where you have put this connection. They said the entire code they have used. So they are saying it's not working on. So that time they said no, it was meant for digital. We didn't know that. We thought it is a green initiative for the court, which E-Court should do. We did not think that it was exclusively for. So even I think I don't know how we were did in West, apart from computers, we were there, right? Some judges' chambers, somewhere in one of the heater lines also. I think we have done it. So we didn't know. We thought, we were minimizing its it's to be used to only very exclusive places, and one of them became heater points. Because how cold is there, and we often frequently, because for DC set this diesel is never there. I do not know why in districts. Jimmy would know why DC set is not there. So diesel is not there. So why not you bring it at once, the whole amount which you need? So that used to be an issue. I mean, cold winter months we used to be without heaters. So we thought, at some points, at least in judges' chamber or courtroom, one point we have used it. So still it's How it is not sufficient? What happens as a consequence? Does it get shut down or something like that?
Whenever we have more users, the DG trips, sorry, the solar trips, when it trips, then they need time when switch on the DG.
Yes, yes.
That is the problem. The codes, sometimes the codes get dark. The computers will not shut down.
So what could be the solution for this? Now we cannot say to them your solar is inadequate, right?
So,
What something else?
actually, we already requested the solar panels.
No, when?
But if it is,
No, you have said you have already made 2 requests, but I am absolutely unaware of this. It doesn't come to me.
sir, one was founded by the principal district.
What's written there?
There's a report stating the solar project and the power required by us, actual power.
To CPC only? I don't think. When?
More than 6 months, sir.
No, sir, I'll find it because I don't think I have read this one because everything is put up. No? I don't think I have received it because why would I not take care of the thing which is exclusively my domain there? I am doing so many extra work out there. So I do not know, I'll try to find it out. The previous one also which you said I have not read it. The case types. Oh, in this front, we are being asked the case types that we are using. Just it reminded me. And for uniformity in the CIS softwares or e-filing, etc. Because the whole country is having different type of case formats. Even in our, sometimes in the districts, what I noticed then was there's in civil cases, a case is not registered until there is a leave granted by the civil court to register it where one of the party is government and section 80 is not complied with. Some urgencies and these things has to be shown. Now what used to happen was the claim gets registered and comes to the judge. There is a leave petition pending. Now, unless I grant leave, why should the claim be registered? So these are the technical issues in the computer. Because now why that was done was because unless the plaintiff is registered, now leave petition has to be registered as civil miscellaneous case or some kind of nomenclature. It was not getting registered. Exactly that happens in the High Court's CIS system, which is 1.0. In that one, let's say for condonation of delay, unless the delay is condoned, where the question of main petition being registered, but that has to be registered, especially so when it is e-filed, because from the e-filing it directly comes to the CIS system, and the CIS does not provide, and this condonation of delay is filed as IA, I think, IA, right? Now, to my understanding, IA is something interim. Something must be pending there. Some kind of, even a spec must be there of the main case or whatever it is for IA to be filed. The very nomenclature is interim application, right? So, or even if you say interlocutory, it's something in between. But you cannot register an IA in the present software unless you register the main petition. For that purpose, the registry is registering the main petition, condonation of delay, despite there being no order of accepting that petition and the delay after delay is condoned. So these are certain technical issues there, which does exist. So to solve all this, because nothing is uniform in the country, we had a lot of argument with the developed softwares who were developing softwares between what is the difference between orders, judgments, and or final orders and judgments. Now our software in the High Court, they use final orders also to mean sometimes judgments also. And what is judgment is being meant is the final order. Let's say in condonation of delay is allowed, delay is condoned, and there's in an IA some order is passed. That is being treated as a final order. Absolutely perfect, it's a final order. But when uploading, this option is of judgment. No, that is not a judgment at all. And when they were developing this e-filing, then we had to, none of the country does that. We have to explain them this is what is being done at our place since quite a long time. So some adjustments were made in that. So because of this, there is no uniformity of use of even the case names in the entire country. Somewhere, I think even if lawyers would go to some Delhi courts, etc., they might be finding different nomenclatures. To my understanding, that particular petition has to be civil miscellaneous case. If it's a civil, right, for condonation of delay, not an IA. If you do civil, the problem is solved. But now we have to amend the whole procedure rules, which is actually being done. but it takes a lot of time to convince everyone and let it pass through. So that's the point of having a uniform nomenclature, so that anywhere you go in the country, even as lawyers, that you are comfortable with whatever is being used. Just like yahi tha hamro त्यो family court ko matter में there were differences, right? But what they did also, I think it's not absolutely wrong, but that was a way out. So in basic IT infrastructure, like solar backup, which is said, that is required because yes, because UPS, I do not know the UPS which we are purchasing nowadays, including of Microtech, that is 1 kVA, 1 VA, no 6 VA,
600.
6 VA, not kVA, 6 VA. Those are actually not working. It doesn't, provide that backup even for a short time. And everywhere there is a complaint that UPS is not working, and the computer team is finding that even though it's not of much age, still it has completely failed to give power. The problem UPS is lots there. So this time we are thinking, instead of buying one each every time whenever there is a complaint, we'll buy about 15 to 20 UPS and keep it. Obviously it will be used within the 6 to 7 months. And another thing I want to tell you is there is very less. We will not be provided funds for printers. Can you tell the reason why? It's common sense. Anyone? Yeah. The committee thinks that giving computer a printer is pointless because we are going into paperless. So printers are not coming. Don't expect about it. And we have given so many desktops, but we have not given any printers. But some of the CPCs raised the point in bigger high courts. We need printers. So in that gap, even if we will be included in that, so we'll be purchasing printers also, because there's really the printers. And as a computer people, please, when you have to impress upon your district judges that funds is ours for replacements. So please don't expect one fine day your server might go away and you might tell our server is no more working, we are stuck. Then we'll just be replying saying that the recurring expenses as per the MAUs of the state, please use your fund. Okay, so that a fund which you are asking the government is some kind of a product of some application of mine, district judge, accountant officer, so and so. So be prepared to meet this contingent, especially of server. So, or main computer of the senior most district judge, let's suppose one fine. District judge will not say, I don't care from where you get it, they will tell you. And if you don't have fund, you have to get, and if you have a goodwill with some of the shops, they'll kindly give it, I'll bring it later on. And by that time, one all-in-one PC will be costing at least 1.5 lakh or 2 lakh goodwill. So it's quite an amount. So districts must be prepared for this. As I said, 2 of the things we have given it to districts only. So yes, printer. There will be dearth of printers, supply of printers in near future because of paperless thing. Because you don't need paper. The only problem with paperless that comes in the trial court, there's no problem in the constitutional courts. There's no evidence to be taken, except which has those original jurisdictions. But in trial court, what will you do with those stones, those twigs, those, or even in paper? But I think somewhere, I'm not sure, the rule says that once the original is the e-filing is done, original can be tendered before the judge. And once the judge says this is the original, compared with the original, then that e-version can be used for all purposes and return it to the party. If somewhere dispute arises regarding to the very identity of that document as an original or not, then the party can always, while in appeal, bring that document and show it. Otherwise, we can't go paperless because Evidence Act still recognizes the primary evidence. Though a little bit of change is there, which I think we all need some time to understand what is trying to tell regarding electronic evidence, secondary electronic evidence. So I want Mr. Dixit and anyone, Jigme is also there, Sharma is also there. You can volunteer yourself for the remaining second part of the schedule. I'll be thankful for that.
So,
You all have seen this practically on the ground.
can we ask, because it's also important.
Yes, yes, why not? No, I didn't see him. Really, because I do not know. Okay. Yes, yes, why not? Sorry, I missed you. So it was not deliberate. Or anyone else who's there. Srinkala and Dichan also, it's open to both of you also.
This time for a change we could have gone.
Oh, see, I will not force. You will decide among yourselves. Or the only person that can force out here is director and additional director. So internet is there, you can use it. Said earlier that we should know everything. I just didn't want to go there and put. I'll just add the CIS software. I think now is the 3 point. What is coming up 2? That is still in test. No, testing is over. We have returned it to the e-committees. 4 point in Namchi. Yeah. No. The previous one which you all tested, it is not 4. It's 4. Okay. That another version is that's completed. No. So I have written it to the committee saying that what you have to do on your part, you do it, right? So new CIS will be coming and e-payment. There's a little bit of problem with e-payment, which I might say. The e-committee says that what is the role of all kind of payments, whether physical that we make in courts. It is the revenue that goes to the state, like court fee, some kind of other fees, fine, etc. E-committee says it should go to the state treasury. Our state treasury is State Bank of Sikkim, which is a protected bank under 371A. Now, they do not want to go online in a sense which is real online. Those, to some extent, they are online. Another thing is that they do not want to share data, because once bank does what we are asking them to do, their data might go to RBI, which is not there at all. SPS is a RBI in itself. To some extent, some improvements have been made. Like prepaid. So we took the example of prepaid power bills. If prepaid power bills can go to the state treasury through online mode, to that SARS Liberty app, why not our? And they said yes. But in the end, what we discovered, that's not true. It doesn't go still to that. It goes to SBI or some other bank or IDBI, whatever they are using. So these are pseudo state treasuries, either SBI or IDBI. In Mangan, they are using IDBI. So the actual money goes there, they carry it physically from there, take it to the bank, reconcile physically. That's the big problem. Why? Because the moment it wants to open up, it will have to share its entire thing with the Reserve Bank of India and be governed by its norms, which they don't want to do, considering a heritage bank, whatever it is. So in e-payment, we are having a problem. Now e-payment, we did everything. We tried, we convinced them. But till then we did not know, they would still not allow us to go directly into their system. The problem with e-payment that came up, there's a concept called defacing. A lawyer e-filing a case, after depositing certain fee, will also, the new e-filing system, the concept is at the present you are printing that acknowledgement, and then giving it. To remove that, so that everything is online, there is one thing called defacement. Once you print it, you can print 10. A lawyer who is not concerned about all these things, I am just speaking practical, there are people who may do that, will print it 10 and every time produce it in the same case, registry might not check it, who has the time to do. You all, at least to a certain extent, unless you fall a prey to that thing, you will not know, you will believe someone who is bringing it. That can be used again and again. So in the software they have given a thing called defacement, which will actually write used, or it can be done in either you can cross it or you can whatever, or used, or completely delete what is in that challan. Now to do this, we have to include this in the software that is there being used by the SPS, which they are not willing to know. So in the end, we are again calling back to SBI. Now SBI is not interested in it's their e-payment gateway, which it's not e-committee's gateway. Now they are not interested in a amount that how much we generate as a revenue. Not even 5 lakhs maybe in a year, unless there is an exorbitant fine imposed. 5 lakh पनि उठ्दैन कोर्टकोबाट revenue. Neither the state would be interested nor the bank. The bank says no. SBI has their defacement facilities, but to integrate with that, they just don't bother. हो जाएगा, but it never happens. So that is the problem. So still in the new, we wanted to get that facility which all the states are using of once you are making a payment, you do not have to print that challan and bring it to the registry or court, whatever it is. So to avoid that, we tried, but there's still hindrance there. And what I said, he's still thinking about what can be done, whether we can go to other bank called what is that, Cidico or something, Cisco. If so, is Cisco still under, or it's independent of? It comes under RBI. So see, there's a problem, but maybe one fine day we may be able to get out of this. Your e-payments are going to SBI actually, okay? From SBI, the SPS physically carries the cash after some reconciliation, goes there, it's not going online, nothing is online. Up to SBI, it's online. And I give the reason why. There's a very fat file which says it can be, but still we are trying to find a way out. Okay, see, if I leave you all to decide, where is Milan? You'll do everything? Okay, come on, be what to say? Be a hero and decide yourself. Leave it up to you.
I'm taking NJDG. So everybody knows what is NJDG. What is the basic function of NJDG is to display the data, which is our case details of entire courts of India. Right? Now we can see this is the link to check the cases that it shows the details such as pending, disposed cases. We have here 1, 2. You can see here drop down 1, 2, 3, 4, 5 drop down. From here we can have sorry. So this is the yes, this is for soaring. So you, I think so. You इसको गेजिङ कोडकै उसमा हुन्छ. मलाई याद भएन सोरिङको चाहिँ डेटाबेस अलग्गै छ कि सर्भर अलग्गै छ कि गेजिङमै छ त्यो याद भएन. They are having undated cases, I think. Yes. तर यहाँबाट चाहिँ हामीले क्लिक गर्न सक्दैन. यहाँबाट जस्ट हामीले कति पेन्डिङ केसेस छ क्रिमिनल र सिभिलको इन्डिभिजुअल र टोटल यो मात्रै गर्न सक्छ. तर आज हामीले भित्र जानुको लागि चाहिँ हामीले यहाँ यो चाहिँ पर्सेन्टेजमा छ हामीले बुझ्दैन. तर हामीले यो बाहेक अर्को पनि हेर्न सक्छ. पेन्डिङ ड्यासबोर्डमा गएर यो जुन चाहिँ तपाईँले माथिको यो देख्नुहुँदैछ यो दिस आई थिङ्क यो चाहिँ सबै इन्डियाभरिको केसेसहरूको पेन्डिङ हो तर हामीले अलग्गै इफ यु हेभ टु चेक आवर इन्डिभिजुअल डिस्ट्रिक्ट वाइज वी क्यान सेलेक्ट फ्रम हियर state and district. For example, Gangtok. As of now, we have total pending cases, civil and criminal, 1118. But तर यो कतिवटा कुरा मैले मैले चेक गरेको थिएँ यो जुन चाहिँ यो डिस्प्ले भइरहेको छ एनजेडिजीमा र फिजिकली मैले सिआइएसबाट हेरेँ र फिजिकल जुन चाहिँ पेशकरहरूले गर्नुहुन्छ उहाँसँग कतिवटा एक्ज्याक्टली चाहिँ मिल्दैन रहेछ एउटा दुईवटा तल माथि भएको हुन्छ उनीहरूले जुन चाहिँ स्टेटमेन्ट माथि हाइकोर्टमा पठाउनुहुन्छ त्यो र सिआइएसमा र इभन यसमा यो जुन चाहिँ एनजेजीमा देखाउनु हुँदैछ यो एक्ज्याक्टली तिनवटामै चाहिँ मिलेको हुँदैन म्याच गरेको हुँदैन
the format which we have, physical format, it has so many nomenclatures, 169 rupees. It's a simple criminal case, non-FIR case that has to be related to this case. Some more other nomenclatures which is not there. So in physical statement, where they are adding some either they are missing. So this is one of the reasons, but it's time, my view is even after the issue arises, go with the software details for it. We will believe this because it's time to believe this. You cannot rely on your data on the physical side may be absolutely wrong, but we will take this as true. As you said, there may be difference of one or two, what difference. So if we don't do that, then we will forever have to do this physical emergencies. The statement derived in the software, which will be built down there, no need to write papers. And one more thing I request
Honorable judges out here, there are two things that comes to High Court. One, the original one which you have signed with your pen, the other scanned one of the same thing through mail. There is a circular from the High Court. If you are sending semi-official and official email, it's acceptable. Right? Even I don't know whether I have already instructed them. Maybe they are sending also. Only send the email. Because one document I have to sign it. That it goes, okay. So monthly statement, I was shocked 1 January. Whole day I signed the monthly statement. Because you don't remember, after I finished 3 of them, again I saw the same statement somewhere else, which I earlier signed it. So even for monthly it is not required. Why? Why will we disbelieve? At least judges won't do that. If someone is playing, rough down there, that's that person's problem, not yours. You have signed it genuinely, right? You don't need it. The same letter comes in a span of 5 minutes, one email and another one you sign. What will I do with both? And our sections get confused after a few days I'm sending. This is a real mess issue out there. There's no, because as we all know, we look up to High Court what they have said. There is a circular. You can ask any Mr. Yalan, give me that circular. Can you don't send? Same thing twice. I would request if anyone is from the academy also. Same thing happens. Forget what do you want to send? I don't know, your leaves are also 2 things happening. One, through email, what is required?
Sir, can the statements be digitally sent now? Because now all the
Why not?
instead of signing
Why not?
PDF,
No, but that should not, even I would be in that place, should not make the peskers using the digital signature. That might put you in more trouble because, as I said, in electronic, the more facilities come, the more ease it will be to you, and there will be a tendency of giving it to everyone. No, I have not done it. Though I have done it. Okay, so many things. No, from the CIs they can take it. We are trying to work on a software which needs to be typed instead of making the paper, and ultimately you'll be signing digitally, and that comes to the High Court.
सर अघि के अरे family.
I'm very sorry to lodge this because of that. It's more specific to the the system which is being used in the courts rather than the what may be more useful to you apart from e-filing. Right?
So अघि फ्यामिली कोर्टको लागि पनि केसेसहरू पनि यता डिस्ट्रिक्ट एन्ड सेसन्स कोर्टमा इस्टाब्लिसमेन्टमा फाइल गरेर चाहिँ ट्रान्सफर गरेर त्यो पनि केस हुन्छ भन्नुभयो। त्यसमा चाहिँ के इस्यु हुन्छ भन्दा चाहिँ वान्स डिस्ट्रिक्ट एन्ड सेसन्स कोर्टबाट चाहिँ फ्यामिली कोर्टमा ट्रान्सफर गर्दा चाहिँ इस्टाब्लिसमेन्ट ट्रान्सफर गर्नुपर्छ। अनि इस्टाब्लिसमेन्ट ट्रान्सफर गर्दा चाहिँ के हुन्छ भने त्यो जुन चाहिँ केस जान्छ उता पनि जान्छ फ्यामिली कोर्टमा जान्छ, तर यता जुन चाहिँ कोर्टबाट ट्रान्सफर गरेको हुन्छ त्यहाँ पनि बसेको हुन्छ। अनि त्यसले गर्दा चाहिँ
as a dispose. No, actually what they are doing is not correct because it's a court meant for different jurisdiction, but still if it's workable as of now, then I wouldn't say anything because jurisdiction the district jurisdiction. That's a way out because that might have eased the lawyers to file 125. Still, don't do anything as it's going on. You all can examine yourself whether to continue with that or not.
अनि त्यही डिस्पोज भएको चाहिँ यहाँ डिस्पोज ड्यासबोर्ड पनि छ, त्यो पनि आएको हुन्छ। त्यसले गर्दा चाहिँ यसमा बेसी उयो डिस्पोजल देखाउँछ हुनु चाहिँ जुन चाहिँ त्यो रियल डेटा होइन त्यो चाहिँ अर्कै कोर्टको।
Yeah, that happens in what we call intra establishment also from Lok Adalat, right? It's showing double same case in committal magistrate registers is that GR case. Same case goes to the district judge as POCSO or whatever session. Actually, the figure to one on but the software so jati sessions court ma cases sir isko tik double data se total ma huncha huncha. These are all issues which something has to be done. Once committal, the committal ma dekhaunu bhayo at least some because if someone says how many cases were filed in Gangtok court establishment all, if I say 1000, right, then if 200 are sessions cases, then 200 are definitely committal also. So 400 by then. 200 is extra data actually. This does not show which is trying to tell. That happens in committal also, which Lok Adalat also happens.
This is
the one if I may talk legally, lawyers also. Can a Lok Adalat dispose of the case which has been referred to it by the court? I think we have a practice of disposing by Lok Adalat, except the ones which are originally filed. Yeah, it should be forwarded. I do not know. Even when I was there, I did get some of the my cases referred to as disposed back. So what do your computer people say? Technically, I have seen this here. Can a Lok Adalat dispose of a case? There will be issues of release of property which the Lok Adalat cannot do.
सेटलमेन्ट हुँदा चाहिँ
Different court to order. File be put up as and when.
cases, what do we call it?
Matters settled
Do we call it
or-
disposal? Because at times what happens when it is referred to the court, so it is marked as LA case number such and such.
Yeah.
And then once it is settled, then we send it to the court, but then the LA case gets disposed of, but the number remains the same in the pending court. So again from there it gets disposed.
So it's double disposal also this also, right?
So then it's getting disposed in
So
the
cannot we
local
revert back to our own original GR number? Transfer चाहिँ हुँदैन लोक अदालतबाट
सर ट्रान्सफर हुन्छ सर एउटा
ट्रान्सफर एज डिस्पोज
ट्रान्सफर भएर गएको हुन्छ उता सेटल भयो भने चाहिँ फेरि यता जुन चाहिँ मेन केस छ त्यहाँबाट फेरि त्यो चलाउँछ सर रिस्टोर गरेर कति
Then it is showing as LA case number such and such is disposed. So it is getting disposed twice.
That's what the core number is always varied. How many local adalat will get the correct picture? How many cases disposed by CJM court? Correct picture. But in total, we are getting it wrong, right? So I do not know. These were always an issue when computer comes in, because law and computer is so difficult to match. I think Lok Adalat cannot dispose of the case. Of course, that computer, that technical disposal is one more legally, because there are issues of property. We will get it. If it's a theft case, will the Lok Adalat decide who shall get the legal property? Cannot go into, Yes, pre-litigation is no problem, because there is nothing in the court at all.
One important tab here is alert. alerts. We can, from here we can see we can check the cause listed today, undated cases disposed. मेनली यो चाहिँ खास गरी हामीले केमा चाहिन्छ भन्दा चाहिँ आजको अनडेटेड केसेस छ कि छैन भन्ने कुराहरू चाहिँ यो चाहिँ भेरी इम्पोर्टेन्ट.
So let's see today. Let's see the real. And is that another one? 2 years, pending more than 2 years. That's always an issue that always comes from e-committee. It's not operated properly. Sometimes undated are due to that technical problem also. It's not getting updated in the server. Which you know. Gangtok है, इपाक्शन है.
Second.
Okay, I understand. You put excessive. Excessive more than 3 months, I guess. Where you are given dates to a case which exceeds 3 months. That is not something not liked by the software. So that you know it, we have put the case too far away.
I just wanted to highlight one thing here in this. When I was district judge here, special division, that time
मनोरंजन एक ही लेके बैठे
one
हैं, क्या कर रहे हैं?
letter from
उनको
the
दीजिए.
e-committee. That case was put up on Sunday. It was in sine die matter because the system will automatically generate the next day. So while generating the next date in the sine die matter, the matter was put up on Sunday. So I got an explanation from the e-committee, so I had to explain. So I think we have to be very careful about that.
I think this happens now because at one point of time, I had specifically written this with suggestions, but suggestions are, believe me, I used to work hard in writing suggestions. It's not seen anywhere, but still don't get discouraged. I had written all this that we should be knowing that the Sundays and holidays should be blocked, so that even if you put that date, it's not going to accept it. It's still not there.
So CIS,
There is a provision where we can update holidays.
Holidays.
Once we enter those holidays, the next date given will be like exclude the holidays.
It does not accept that date, right?
It was not a state holiday, no, it was Sunday actually.
No, I think Sunday also we can include it. I said it's been done. It's a good feature, no? So North. Please take care of that, okay? Correct, I know. Got this, sir? So, North is remaining. Shinkala, please check. So, the moment the tester tries to put that date, it is not accepted.
it is sure that it is a holiday.
It shows.
It depends on the tester how
It shows? What's the
Rate.
So in the beginning of
It accepts
the
it. Then the great thing that everyone can see. It should not accept it actually. Okay, in any case, improvement than before. You can update your own holidays. That's the issue.
It depends on the tester or whoever giving there to see that it is marked as holiday and not to give.
One pesca is right behind you. He is looking.
Once
Use
you
this.
talk about the state holiday,
Use it.
the
System.
recognize all the
No, technical.
No, I know CI is technical, but there's nothing wrong in going inside it and seeing. You have your login, not just to update cases. And you are a person who would like to explore till it gets damaged. So now, I'm just joking. That last person and this joking.
now we have last tab.
He is a mini explorer.
Information management. From here we can check the song.
You saw on the trial, on that example, on the trial.
Which means
On the trial report.
okay.
On the trial is also there. Let's go to one which is more relevant. Sikkim on the trial. Previously, we had very poor recording this. Now it's improved a lot. But still, you can see how much on the trials you will have and whether it's reflecting true or not. Gyansin has 0. Is it true? Select this one.
Then I think inside you get a different figure. Correct? Gelsi.
Zero.
This may not be true. On the trial, they all under those data are answered here who are in custody.
The data is not in
This is for Gangtok.
Till I was there, it used to be entered. So it's the district and session judge. Is it Gangtok? मैम सीधे 37 र 46 त सही नै हो जस्तो लाग्यो. CIS even has a provision of those who are in the remand. त्यो डेटसम्म हाल्ने those actual trial सुरु भएको छ त्योहरू हाल्ने पनि छ, but it's hardly used. In West I use it. One, if you do that, the correct it will show correct numbers out here. So these numbers probably are almost, I don't know, South Ko it appears to be correct with the number, but Gangtok it's always more than this job of pester or some clerk who is out there. The moment charge sheet comes, the first thing is there's so many things. Because as you said, as Mr. Milan said, the data is not matching with the physical, and these are the reasons. We are not giving the inputs.
Scoring.
No. They have not entered maybe. Which of this? No. Still in the Oh, at Soaring, no? No, he is someone who is a computer literate person. No, tell him to update the details on the trial in the CIS. Okay? Yes, please.
This much?
Anything that could be relevant to lawyers? Which one? Lawyers like I'm learning.
Lawyers like I'm like a mini or lawyers like I'm like information त केही जान्दैन लयर्सहरुले जानेछ त्यो पेन्डिङ केसेसहरु disposed केसेसहरु
This NZDC is actually not made for saying how many cases I have, okay, where is the what to say, it is not meant for finding specific details of the case. It is for data, National Judicial Database. So if you are looking for some data, this is the best place to go instead of your CIS or website. But if you want to know specific about your case, then you have to go to the website, the court's website. There are the details of it. Here also you can go. But why it's quite difficult. You have to go very deep to reach to the particular. It has been purposefully done so because people would go here to look for data, look for the specific details. It's not meant for that. So it's difficult to find specific details. You have to go very deep inside. With each screen you have to go. This is only for knowing how many data. It's meant for most of the stakeholders like researchers, etc. Or for a judge also who wants to know overall picture of his court, the cases. It's meant for that. If you want to be specific on some details, then this is not the correct place to go. It will take time. You can go to eCourt's website and find the details. This is eCourt's website. You can show this. There are certain issues with this new website, but let it be as a problem. The whole country has a problem.
The map of Sikkim has to be updated. There are 6 districts.
Now, this doesn't mean we need to stick to these websites only, okay? It becomes quite difficult to think just at one level. If there's a company of people, then more thought can. We all can all. Just Namchi has his own website. There's no problem in having that. No one will say no. And it's being updated. I don't think so because it requires money.
So I think we removed that.
Why? You could have kept it.
After this new reports, so website.
This is mandatory. We can have always what is optional. We can make a better one out there also. Okay, then open the website, Gangtok website, main page, home page. Could be some of the relevant. Upper district.
So this site is long distance to previous.
So this is why Kerala says we want to have our own system. So they have done also. Okay. That's why I said, why you deleted your website? You shouldn't have. You shouldn't have deleted. So in any case, because that how much money district can manage that much? You could have done your own thing out there. No? Okay, any more in NJDC or any other topic you want to take? We have to stick to time also.
This was
Okay, what's the next topic?
e-filing software.
E-filing, yeah, Mr. Bungal.
Demands for the bar also to have physical training on e-courts, but unfortunately, today I learned that none of our bar members have registered their names for 24th training. So I request
What is that?
24th Mapani training has been
Okay.
organized by Judicial.
No, lawyers don't come to the, what do you say, river. River has to go there. That's lawyer, right?
So I'm taking e-filing.
No, they will not come. You'll have to go. No, I need it.
Yeah, go.
Cases, even I wouldn't have come as a lawyer. But it's so different out there.
There are grievances, there are cases which on that day in the court.
No, it's so different to be a master of yourself. You know. No one of the job provides that. You can, if you sleep, it's yours. If you wake up at 5 o'clock, it's yours. It's difficult to manage because there's always a tendency to sleep, you know, than rather to go to work. So that's why I'm saying they will not come, you will have to go.
So I'm taking you, all of you to Google first. There, kindly type High Court of Sikkim. Now open the website. E-filing and e-payment. Now here there are two components. One is e-filing and other is e-payment. If we are filing, if you are filing, the lawyers are filing civil cases, then they must have to pay court fees. So for that reason, first you go to e-payment. If you have the court fees paid at hand and that that paper
This is a cumbersome process actually, which as I said earlier, we are unable to remove it because of the SPS thing, right?
Yes.
Because they are making the payment first, printing out from there, uploading it in the
Yes.
e-filing case, right? Otherwise, it's integrated system. You go to e-filing directly, there will be the payment system inside it. You pay there, don't need to print anything. The registry will receive the payment information. That we are unable to do it because of SPS. How do we go about it? It's still.
I'm not going into the registration part because I hope that everyone as of now has their own registration.
I'm so sorry, Mr. Kunal, law secretary. I have seen one solution. If all these online payments, is it necessary that physical state treasury has to be inside the SPS? I don't think so. One of the banks which they are actually doing it are working actually as treasury. All the fertilizer, IDBI, etc. This can be declared as a treasury, it will be pseudo treasury. We can always go online business out, let them take the physical. Official recognition of this is not there. Bank says we are online, but what is actually inside online, they are not trying to officially
But
declare.
it is for the government to decide whether they want the nationalized banks to be their treasury.
But they are
in
not
particular cases.
looking a way out of this.
You can always request the government that for High Court, please,
That's what it happens. High Court's thing is the amount is very less. No one is interested. If it's a bigger revenue like electricity, etc., then one of the bank can be said to be a treasury. It will be a pseudo treasury actually. That is what is actually happening now, so that we can directly do it out.
there are certain limitations to that for the state government to implement. I don't know, but we can always try.
And this is the solution. Only that is the only solution of going completely online in every sector also. Yeah, absolutely.
So take me to e-payment. Payment category. Okay, I put Gangtok. Now, say for example, we are filing cases before district and session judge at Gangtok. So court name, this is establishment, now court name. So for example, district and session judge Gangtok. Party's name. Advocate's name, it's not necessary, but we can put type of fees, court fee. Then you write the amount, say for example, 100 rupees. So remarks you can put here for what purpose you are paying the court fees. Then individual and organizations. If you are filing for state, then organization has to be selected. Otherwise, if you are filing as an individual, individual already is there. So put the name again. So for example, my name. Now date of birth, there is static mark, so you need to put that. Mobile number you put. Then email ID may be required, or it may not be required. Now I have written update this. Then the image shown here, W5NK6. Now move on to next. I put bigger amount.
You would have written one and paid it one.
So this way, this another chart is displayed. Then you can put, you can click next. Now there is payment mode. State Bank of India, bank charges 11.8. Other banks, internet banking. So both ways you can opt for. Card payments mode is not available between 23 hours to so and so.
UPI is not there?
UPI is not there. UPI is not there. So let's click here. Okay, now you have to put your internet banking password and all. Then thereafter you will generate court fees payment receipt. You may print that or you may not print that, because you can save it in PDF format. Thereafter, when times come, you can upload it in the main website. So this is one part, payment part. Now once it is ready, once we are ready with the payment, then we can move to our e-filing. But before that, we need to be ready with our plain documents. The another part is, if our plaint is bigger in size, sometimes we write too much and we may have so many documents to be filed as an annexes. So if it crosses 25 MB, I hope, the system will not accept. You can compress it by using online mode of compressing websites. You can find it in the Google. Otherwise, what we can do is, we can scan it in part.
So have you ever been with this situation where it cost 25?
Yes, yes.
So what was the number of pages that would constitute 25 MB?
If we process 200 pages, then it may.
It's quite a big one. It's
Yeah.
growing much.
Yeah, sometimes while filing MCT cases and all, and other plaints also of a big nature, we may face this problem. To curtail that problem, to do away with that problem, we can scan in part, and we can compress size also. I'll just show how to compress the size. Go to Google. Google will do everything. Compress. We will have that document scanned in PDF format. Then you can do compress PDF online. Compress PDF online. We get number of websites. I love PDF is a good one, so we can always use this. Select PDF files.
Why do you think this is free? This is free, no?
This is a free
Why?
site.
It's used
There is another Adobe. Huh? No,
It takes your data.
yeah, it takes the data, it wants it. Whatever you want to turn it.
Data.
You want to know, they're studying actually, no? But no problem.
Nothing is free in this.
Yes. Anyway, to do away with this, we can also scan in fragment, in part. Say for example, you can make 3 files out of 200 pages, 4 files out of 200 pages that may rank between 10, 20, 21 MB like this. So once we are ready with that, the documents and the plans or whatever may be the petitions, then thereafter we can go to take me to e-filing section. Okay, now we need to have user ID and password to login. I'll just put my user ID. Now login. So every of us know that this page will display now. Now if you want to file a new case, see there are so many filing options here. Sometimes you need to file documents in the ongoing case. Sometimes you need to file civil misapplications also. Sometimes you need to file affidavit before the High Court also. So there is little bit confusion regarding that. When we file affidavit in the High Court, sometimes we file in IA. So that has to be avoided. That will not be accepted by the registry. For that, we can go with the document options for filing affidavits in some of the matters in the High Court. So for the new case, we should go to new case section. We are filing in the law court, trial court, district Sikkim, Gangtok, okay, civil. So matter type, it's original. Case type, title suit. Title suit. Is the MSCT matter? No. If it is MSCT matter, then we can put yes. We write here, we select here ordinary, then submit. Now after putting this data, CNR number I think will be generated. Okay, now if you are filing for organization, then select organizations. If it is not for organizations, we are filing as an individual or for on behalf of our client, then don't select it. So here we have to give the name of the complainant, petitioner. Relation. So name of the father of the petitioner has to be mentioned here. Date of birth is not required. Age, it is mandatory to put age. So for example 58. So a female, email ID. If your client doesn't have his email ID, we can put our own email ID also here. So mobile number. Select state, select address. State is Sikkim. Taluka, it is not mandatory. Now, put pin code. Now save. I think district need to be selected. Gangtok. Now Taluka will also come, I think. Okay, Gangtok. Town also Gangtok. So ward not required. Now police stations will also come. Gangtok. Now save. So my data has been saved now. Now we can move on to the next page. I have taken much time, therefore I am logged out. So we need to ensure that we are in time while filing the cases. Okay, now the earlier data has been saved in draft. Okay, from here we can see and move on. We have given the informations of petitioner at the first page, and now respondent's information, the opposite party's information. Same as the case of petitioner, relative father's name is 56. Email is not required in case of respondent opposite parties. Address is required. So select state, Sikkim, Gangtok, town Gangtok, give pin code 737101, police station Gangtok. This data are required for sending summons. So make sure that you fill up all this. Now again, we need to save the data first. My data is saved. Now move on to next. If you have 2 or 3 or more than one petitioners, complainant or the petitioner, this is the correct page where we can put the details of those extra petitioners. If you do not have, then move on to the next section. So extra respondent information is also given there. If you have 2 or more parties in the suit, you can put the information of those persons here. We do not have, so save. Move on to next. not selected the state, so it is not moving into the next page. Okay, please note that once it is also given there, once you submit this e-file, cannot modify extra party later on. If you have extra party, we need to put here itself. Otherwise, we cannot later on modify unless it is given in defect by the registry.
I'm on the second.
Okay, now I have filled up the extra parties informations of the, if there are two participants, I have put that also, and in the respondent side also I have put. So now, after putting all the details, we are in the case detail page. Cause of action, you write cause of action.
This is still the older version, right?
This is still older version, sir. But
Yeah.
I'm finding, sir, this important information, sir, subject or reason that was not there in the older version, sir. I think it has been updated.
New one or old one?
Is this old one?
Yeah, we are ready with it. We have sent all the details. On our part, we have done our job. We are waiting their confirmation from their side.
But
Right?
but
It was tested also. Some issues they were pointing out. But I think it will be you only, Mr. Rathan, because as a judge, I do not know much of this e-filing. Because I have never filed e-filing.
New version hasn't come, no, sir?
No.
So we can put important information or subject or reason here. Why are we filing the suit? Then prayer. What are you asking for the court? So we can say, for example, declarations of right. Then cause of action. So say, for example, 1/5/2024. What relief you have claimed? If you have claimed any monetary relief, then you can put it here. That section is also there. So dispute arising out of, this is for jurisdiction purpose. Gangtok, Taluka, Gangtok, save. Case detail added successfully. Now move on to next. Here, information regarding act under which order, which sections we are filing our case. We need to put it here. Okay. Code of Civil Procedure. Code of Civil Procedure. Section 9. If you want to add more, then there is option. Add more option is also there. We can sometimes what we do is section 9, order 7. So all this. Save. So on to next. Now this is the important part, because we have to be careful here. So far our practice we have adopted is uploaded and later on e-verified using mobile OTP. Kindly select this only unless we have digital token or other verification. So I have clicked on update, uploaded and later on e-verified using mobile OTP. Now say next. Now here select the document. Okay, let's select written statement. I am not getting plain here. It may be in a different name. Okay, now choose file. So documents title we can give. Written state means choose file.
You can use that deed.
Deed of lease, sir?
Yeah.
In the PDF format.
Yeah.
So here, the earlier I was talking about this, we can see in the notes section, please upload PDF file only. PDF file name, sometimes we stock down here also. We give names of PDF file in the character which is beyond permissible limit. So character is only 45. We need to shorten it also. Only digits, characters, spaces, hyphens and underscores are allowed. Maximum PDF file sizes, it's only 20, not 25 also. I stand corrected. Its size is 20 MB. So deduct this, sir. So mine is uploaded. Now if we have made 3 sets of documents, we have to upload it here. Now I have uploaded it. Okay, next.
How do you sign this? Because I hear that signing is done on
Yes,
paper
sir.
itself and scanned and put up.
Yes, sir.
This digital signing is not opted for.
Yes, sir. Mobile e-signing is there, sir. I have selected that options. Now, later stage, if I upload these documents, at the next stage, they will ask me to verify it through mobile OTP. So that is there.
You can go with one document only as of now.
Yes, sir.
You don't have more documents.
Yes,
Let's
yes.
assume.
Let's assume we only have one document. So we are moving ahead. Now here, again, that receipt, so we'll upload one document here. Fee type, court fee amount. So why fee is needed to be paid at first? Because every time if we take much time, then we get logged out. So if we have that ready in system, then we can forthwith
Okay.
upload here.
It means to say if we are idle out here for a longer time, it gets logged out automatically.
Yes, it gets logged out automatically. So fee amount is 100. Payment mode, e-chala. Bank name, State Bank of Sikkim. Okay, now here we need to put the challan number, the one that has been there, that will be there in the right hand side of the challan. यहाँ चाहिँ एउटा चाहिँ के हुन्छ भने नि त्यो चलानमा चाहिँ I think the numbers are more than what has been specified, what has been the limit fixed here. So we can do away with the numbers part and then write त्यो DW पनि के लेखेको हुन्छ नि legal aid cases मा legal aid cases मा चाहिँ we
पैसा देखाउनै पर्छ जस्तो लाग्यो.
देखाउनै पर्छ.
अच्छा हो.
हैन
It allows, respect that.
Not necessary because in all the proceedings not necessarily at speed.
1 rupee, I think. Skip
Okay,
the process.
let's try it. Let's try it. Let's not upload anything here.
Okay.
Let's do the next.
No, you have to remove this mandatory fields, 100 which you have written.
It accepts. It accepts.
If you just write it also, it accepts.
Yes.
So it means to say you write the money. Write something in that mandatory star field, asterisk which is given, and then proceed. The thing is, you will not be producing the challan before the registry or whatever it is. Is that true? I do not know you are happy.
Without paying court fees also, we can move on to the next page. Because
Skip the.
yes, not escape. You need to click on to the next button.
Maybe the new, I do not know, the new e-filing may be solving this problem.
See, I was here.
Consumer, yeah. Remember once I spoke to you about consumer.
I had heard this lawyer has raised this point. In your specific trade.
Consumer has e-dakhil. It has got different that. But we can I think skip. See, I'm again on the same page to clarify this position.
I think I do not know. Because the system which we have adopted, as I said, the problem is that our online payment not going to the treasury. So we are doing it, this is SBI payment gateway, created gateway. Because that money has to go to the treasury, the e-committee procedure says, which we are unable to. So we are externally paying money to SBI, and SBI is collecting that money physically from SBI. So I don't know, that's why, otherwise such an pertinent thing that legal aid cases don't require money should have been in the back of the mind of the software makers or whoever is doing
Yes.
So because it's our specific issue.
Yes. This system doesn't identify whether you
Let's wait for e-filing. What's the version? 4 to come. Let's see. I think that will make it more difficult because they are saying the integrated payment is mandatory. I do not know how we are going to implement it. They said to us, I said them, okay, on their face, that the law here is not permitting, I can't do anything. They said, that's your problem, we don't care, you do it how you want to do it. But it has to go to treasury, they are still insisting on that. We kept the SBI people also in the meeting, but nothing came out. SBI, sorry.
Okay, I'm again back onto the same page. I have removed every details I have put. Let's try it here because this system does not recognize whether we are filing legal aid case or other cases of private nature. So let's not put anything here.
Another threat they have said is once if a timeline within which this, if you don't implement 4.0, then we are going to stop this support. So if that what they are saying comes true really, our e-filing is going to stop completely. If we are not allowed to externally pay the amount. So I don't know, that might escalate things actually.
And that 4 is much easier, much compatible to the lawyers, I think. That is
Would
more.
might be available because I think registration to any other, you can file cases in other courts also, right? In 4 they have made mandatory to give the names, email, phone number which we have updated. And we ask them what is the reason you want it. We forcefully put in SK in front of that, your registration. Some have WB, some have F something, some have Punjab and Haryana, some have South Down, South, Bangalore. So our registration is a unique case in Sikkim that the lawyers practicing here have different registrations who are registered prior to coming into the force of that Assam Bar Council something. Only that, even in that, for certain years the nomenclature is quite different. So what we have done is, if in future it's required, then you will have to, may have to mention SK in front of your registrations. Because we have given on our own as SK because they said you have to give the state name. So do not, unless that 4.0 comes, we are unable to say how.
I think that has been done in our registration time in the High Court also.
Yeah, we added SK on our.
Yes.
We removed some WB or F something and
Yes.
SK.
Because whoever has
Only the
registered
digits of your registration we have given as it is. Remaining numeric, alphabets we have changed into SK.
Okay. Now let's click next on here. It accepts. So, Jola Madam's anxiety is gone here.
What is this front word out there near the view?
View applicants come and litigate information, sir.
I think this is all of it, right?
Yes.
Okay, in this signing, no, why Aadhaar signing is not being opted by the lawyers?
No, those whoever have updated
Yeah.
phone number with Aadhaar, I think they can do
That's
that.
one of the very easiest.
Yes. I get
But you
messages.
need to update your, if you have lost that phone number, you need to update it. If you have never connected your phone number, connected is not the correct word. What is
Registered.
Linked to your phone number
Linked.
with that Aadhaar, you can always go to that Aadhaar office and do it. Not only in this, in many other e-system regarding governments, etc.
Yes.
Okay, that Aadhaar is asked. In fact, in coming times, even for banking transactions, they will mandate this Aadhaar because the government wants all of our details within the Aadhaar. So I think that is one. And OTP one also, how does it work? What happens once an OTP comes? It signs with your name also. It gives your phone number. How does it?
No, everything comes.
No, there must be some signification of signature, no, what you have done. Just like in Aadhaar, it says Aadhaar basic signed by so and so.
It is basically not a signature but a verification process. If I have my mobile number linked with the Aadhaar,
by saying something.
OTP comes and we'll have to put that OTP in the system, then it accepts my profile there.
Somewhere it says it has been signed by the lawyer or party, whatever the case may be. Right? Somewhere when it comes to registry, we will be knowing it that it has been signed in some. It may be mentioning something that this has been signed. Otherwise, how will we know it has really been signed?
Yes, who has signed what? So this part is coming up here. Applicants, complainant, litigant affirmation. So here we need to put the name of the applicant, not ours, not the lawyers, and applicant's mobile number. So
OTP goes to that person.
Yes, that person.
Because double signing in case of this.
Yes.
The lawyer as well as the
litigant
party.
Okay. Here.
This is quite complicated. In Aadhaar based, is there double verification? I don't think so in Aadhaar based. If the lawyer side is sufficient, I guess. I do not know. I feel that way. Only in this OTP one, it goes to both. I'm not sure, but I think that is. It is complicated. No?
Yes.
The party will not know what to do.
Many a times, even the phone number which is being set of the client, the lawyers will put in their numbers already.
Yeah, understood. For ease, it can be done. But that's what I said. When the OTP comes, they may be dragging us somewhere else, not logged into whatever it is, then it's an issue.
But this may be for the reason that
the best is digital signature actually.
Yes, digital signature is best. I think for that part also, for that matter also, this will come because this is the verification.
Oh, you mean to say for every process there is double verification?
Yes, because the applicant has also to be verified by the system and lawyer has to be verified. It's a verification process only. So applicant's name, कसको नाम दियो एउटा मोबाइल नम्बर एक्स्ट्रा चाहिन्छ मलाई कि सो दिदीमा जोडा मोबाइल नम्बर 9734 190 663. So OTP will come.
So in case of Mr. Rabin gives his own number. That's better. Yeah, even they will say you do it yourself. I paid you and so on.
90.
Yeah.
90. 11. 61. So verify OTP. Now litigants information has been verified, verified by the system. Now we can see certificate also here. Okay, this is the sir. You यसरी आउँदो रहेछ नि information. I KD so and so, resident of so and so, for me and on behalf of all the state and so long information that I have gone through these statements. So this is basically a verifications by the litigant.
Understood.
Yes. Now thereafter the advocate identifications and verifications. Okay, I'll give my own name. Send OTP.
is appears complicated, but it is not so
Yes.
because we have not used it. Because I had seen Mr. Jagyan online, paying his income tax. When I saw what he was doing, for me it was something kind of complicated, but for him it was so easy. It's just because if we are not using it, it appears to be complicated. The process which you saw appears to be complicated, but it's not once you are used to it. Just like the income tax also, if we go to its portal, it's quite easy, but we have not done it, so it is complicated to us.
So this is basically advocates verifications. It has completed. Okay, now let's move on to the next. Now we have verified our pleadings, our e-filing, and it is completed. Okay, now in earlier occasions when we were not much fancy with this application, this website, we would miss final submit. That is on the right hand side.
Okay, in the bar, most of them are resorting to this one, e-filing, because I Court they say it's 98% that's e-filed.
Yes, yes.
Nowadays. Right?
Where
And Tasilum in the south or you in west, no? Or south? West. There are mostly were in south. Okay. So e-filing is being done there, right? North Market. So I think if you have done, we thank Mr. Yeah.
Okay, now final submit. Let's not forget to click on that. Final submit on this. Click on that. This will not be submitted.
It's the seventh steps. Otherwise, even on the law,
yes, I have submitted finally.
Wedding ring.
Now the submitted things will come here. Pending acceptance. यो अब कोर्टको रेजिस्ट्रीले हेरिसकेपछि they'll approve or disapprove it. अन्त यिनीहरू उहाँहरूले डिफेक्ट्सहरू पनि निकालिदिनुहुन्छ. In case defects has come, we can see here. यो पेन्डिङ एक्सेप्टेन्सको मुनिपट्टि चाहिँ डिफेक्ट्स आइरहेको हुन्छ. सो यहाँ क्लिक गऱ्यो भने that defects we can rectify again. So thank you so much.
So this can be filed anytime, any of the day or night, whatever. But
anytime.
If it's filed at 12, post 12 o'clock, it will be for that next day, right?
Next day.
No, sir. As per that, I can't even use. If it is beyond 4.
Beyond 4.
So it goes for the next day.
Oh.
Okay. Then
Limitation is
I think it has to be taken as 12. I do not know.
The rule says that. It's your last chance for your
No, for limitation we count at 12 night only. No problem.
12 night you can be sitting at the court.
Yes.
But maybe that is for ease of administration. For delay you cannot say that it was 4 o'clock rule says you have to say.
That may be for the reason that maximum time permitted to file physically that has been limited to 4. Earlier it was 2. Physical it is limited to 4. It was limited to 4.
Online. That's what.
Yes.
Okay. No, for condonation we'll have to take it as that day only. That's a legal thing, no. What you said is for administrative purposes. But still in the district, suppose there is delay and the district cannot insist that, no, it is 4 o'clock. You have filed at 11:59, it's next day. I think that should not be done. It will raise a needless issue. Ultimately in law the court will say, no, you have to count it.
So we have filed the case. Thank you so much. Bearing with me again.
So, Madam Deputy Director, next time those who are trained today as master trainers, you should call them as resource person.
Yes.
At their pocket. The new ones, not the ones who have already done.
No, we have lot of e-committees, e-training programs. So we will be calling.
But lawyers have their own grievance, but this side have our own grievance that only Mr. Tasir Abdan as a trained lawyer would agree to be and Mr. Dungar's name also, some also, but the rest they have gone somewhere. I do not know.